All right, Mr. James, we're going to start with you in just a second.
Okay.
All right, everyone. Thank you for being here. I'm sorry we're getting a slightly late start. There's a certain someone who's been talking to the media about a certain special purpose grand jury that has yielded lots of phone calls. So we're working through that. I don't know what Ms. Nelson is doing, playing the cymbals over here. We are this afternoon calling a trial calendar that will yield a trial that goes out next Monday. Only one trial, only 1 week. I'll be the judge, not Judge Emerson. So that's how it'll play out. But come Monday morning at 9 a.m., a handful of the cases from this calendar will be reporting, and one of them will go to trial, and we'll have jurors aplenty for that case. I will let you all know by way of email what those top few cases are. I'm not going to make everyone who hasn't resolved their case by Monday show up, but we will have a few backups in case whatever number one is doesn't go out. I'm going to call the calendar today to get announcements. Really, I just want to know ready, not ready. If it's not ready, better be a good reason why. This calendar's been out for a while. There are not a whole lot of new cases on here. If it's a case that can be resolved today by way of a plea, let me know that. Hopefully there won't be a lot of, oh, could I have a pretrial with the prosecutor? Because this calendar went out a bunch of weeks ago, and that's what you should have been doing over these past bunch of weeks. With that, our first two positions are Mr. James, who is on the screen. He is, I think, at Grady. And Ms. Roberts, are you on the call? You are on the call.
I'm on the call, Your Honor.
Great. I'm going to add you to the spotlight. There you are. You look like you're behind the steering wheel. The car is not moving?
It's not, Your Honor.
Excellent. All right. Ms. Roberts, I know you had some trouble locating Mr. James. There were a bunch of crossed wires, and we didn't know exactly that one could meet with a client who is at Grady. We now know that. But why don't you let me know, Ms. Roberts, where you are in resolving Mr. James's cases. And Mr. James, hopefully you know this, two of your cases have already been resolved. You had Mr. Byrne on one of your cases. The state dismissed that. And hold on, let me mute Brianna. There we go. You also had a marijuana case, and the state dismissed that. That was old. That was from 2019. So I think all that's left are two cases, but Ms. Roberts seems to find new cases for you from time to time. You've got a gun case and an aggravated assault / arson case. Ms. Roberts, tell me where you are in terms of being ready or working with Mr. Jordan and your client on resolving these.
Your Honor, we've had extensive communication in reference to resolving both his cases. At this time, we will announce ready for trial on the 22-SC-18407, which I believe that's the first one to go. I haven't had any conversations with Mr. James since the last time I spoke to Mr. James on January 30th.
Hold on one sec. We had another person join. I just muted them. Keep going.
Yes, Your Honor. So my last communication with Mr. James is that he wants to proceed to trial. So we will be announcing ready for trial, subject to me finding out what exactly is Mr. James' condition. I was trying to go to see him now. As Your Honor know, I just found out that I can go and see him. I just found that out today.
Okay. Mr. James, you don't need to reveal anything you're not comfortable discussing in this rather public setting. But how long are you supposed to be at Grady, and when do you think you'd be back at Rice Street so that Ms. Roberts could spend some time with you?
Well, I'm supposed to have surgery tomorrow, so I don't know how long I'm going to be here at Grady.
Okay, but you're scheduled for surgery tomorrow.
Yes, sir.
Got it. All right. Mr. Jordan, this seems like a case that we ought not to be trying to tee up for trial on Monday. If Mr. James is getting surgery, Ms. Roberts doesn't need to be bugging him at that point. And Mr. James, have the medical folks there given you a sense of how long your recovery would be? Are you going to be at the hospital for a day or a week after surgery?
No, sir.
Okay. Well, I'm going to let you and Ms. Roberts work through that. And I think Ms. Roberts, just so that you and in particular Mr. James can be as prepared as possible, and Mr. James not be under the influence of any painkillers or anything like that, we ought to bounce these two cases to our next available trial calendar. Is that all right by you?
Yes, sir.
And Ms. Roberts?
Yes, Your Honor. And Your Honor, may I ask, I guess there's a deputy there with him. I'm just having a problem reaching anyone at the sheriff's office to understand or find out what's the protocol so that I can come up and answer him, because I can't get an answer from anyone.
Sure. So there may be someone there. We also sent an email out. Ms. Nelson did earlier today that listed, and it went to you. It lists a Lieutenant Volley and a Lieutenant Gaston that you could call. But let's see what anyone on the scene says.
Hello, I'm here. That's
You still there?
Yeah, I'm here.
Okay. How would Ms. Roberts get a chance to meet with her client, Mr. James?
She can come. She can come to Grady. As soon as she contact to Lieutenant Gaston, and then she can come to Grady to see her.
Okay. So Ms. Roberts, that's one of the names I've got. I'll give you the phone number. Actually, what I'll do is, pardon?
I'm sorry, Your Honor. I already have the phone numbers. I was saying that I did receive the email thanks to Ms. Nelson. I'm just saying the issue is that I can never get an answer. So I just
okay. So
I'm
you
not trying to
call
throw
those
anybody under the bus, but
okay. So you dial those numbers and you don't get an answer.
yes, Your Honor.
Okay. Deputy, what's your suggestion? If Ms. Roberts is heading to the hospital now, she's got this phone number for Gaston and no one ever answers. So what can she?
If she come to Grady right now, she can be able to see him.
Okay. So when she gets to Grady, what does she do when they say, "Oh no, Mr. James is in lockup"? Does she ask for Deputy Eugene?
She have to go to Grady detention. Like you have a Grady detention. If she go to the hospital, they're not gonna let her come. So she have to go to Grady detention, and then I'm gonna call them down there and then let them know she's coming.
Okay. So why don't we try that, Ms. Roberts? If that doesn't work, please let Ms. Nelson know. And I know Lieutenant Volley, so I will get in touch with him. He's on the security side, not the Grady side, but I'll make sure he makes sure that you can meet with your client.
Okay. Thank you, Your Honor.
All right. Thank you.
What time?
Ms. Roberts, what time do you think you'll be at Grady?
I'm getting ready to come right now.
Right, but does that mean
I'll be there in like 20 minutes.
You can give a call on 404-616-0634.
Okay, and that's your contact number information?
That's our Grady detention. When you get down there, you can call them, and then they're gonna let me know you're down there, and I'm gonna go to touch with.
Okay, thank you, sir.
all right, fingers crossed that works.
And Your Honor, if I may, I apologize for saying in an open court because I just realized that yesterday in the evening, Mr. James also had an unindicted matter that was just indicted on the 17th of February. The case number is 23 SC 186244. Ms. Roberts, that's the case we had previously been discussing. It was indicted with the charges that we originally talked about. So just wanted to make the court aware of that. It's not currently before Your Honor. I have sent an email to get it transferred here since he does have two open cases in this courtroom.
What are the charges in the 23 SC case?
It is multiple charges of criminal damage to property in the second degree, and I believe a firearm charge as well.
Okay. All right. And Ms. Roberts, that's a case you'll be able to take as well?
Yes, Your Honor.
Excellent. Good answer. That's what I was hoping to hear. We might as well have you handle all three. They'll either be resolved all together or we'll try one and see what happens with that. And we'll go to the next one. Most of all, let's focus, Mr. James, on you getting your surgery. Get through that. Once you're through that, you and Ms. Roberts can figure out what we're doing next. I'll make sure you're on our next available trial calendar. You've been in jail for a long time, long enough that you're having surgery while you're in jail. And we need to either get you out or get you to trial and a jury says something and then we get you to a different facility. Okay.
Okay.
All right. Thank you, Ms. Roberts, for sticking with us.
All right. Thank you, Your Honor. May I be excused?
Yes, ma'am. And thank you, Grady, for plugging Mr. James in.
It's okay.
All right. Okay. Next up is Shari Grant. And that is Ms. Feely production, which means today, Ms. Primovic. There's Ms. Grant.
She's ready, Your Honor.
Great. And Mr. White, now, are you ready to go on Ms. Grant's case?
Ready.
Ms. Grant, when you were here before, you and I had a discussion about your child, and you told me that by this calendar, so late February, early March, you'd be able to have your child not be down here for the trial. Is that still correct? She'll stay with your father or someone? Stay with whom?
My cousin.
Okay, but you've got a place for your child to be so that you could be in court, not distracted by your child. Okay, and if court runs from kind of 9 to 5 each day, your cousin will be able to be there for your child during that window? Okay, all right. Mr. Whitenauer, how long do you think the state's case will be?
Say 3 to 4 days, Judge.
All right. Any sense, Ms. Primovic? I know it's Ms. Feely's case, but.
That sounds correct.
Okay. All right, and both sides are ready. All right, Ms. Grant, we will likely see you here on Monday morning, but I'll send an email out to Ms. Primovic and Ms. Feely, and they'll give you a call to confirm that. But assume that you'll be here Monday morning. Whether your case is the one that goes out or not, I'm not sure yet, but I bet you're going to be on the short list of cases to be here on Monday morning. Okay? All right. Do you need Ms. Grant to stick around? All right, Ms. Grant, you're welcome to stick around, but you're free to go. Thank you for coming. I know you come from far away. All right. Thank you. You're welcome. Nedra Edwards.
Good afternoon, Your Honor.
Hey, how are you?
I'm doing well. How about yourself?
All right. How's the C3 project going?
It's interesting.
It's interesting. We appreciate your participation in it.
I do what I can, Your Honor.
And there's Ms. Edwards and there's Mr. Jordan. Are you ready to go?
That case should be resolved today.
Excellent. Is that your understanding, Mr. Jordan?
Yes, Your Honor.
All right, Ms. Edwards, I need you to sit tight. I told you I'd get you a lawyer. All right. Vondi Humphrey.
Good afternoon, Judge.
Good afternoon.
This will be a plea today.
What are we doing with the CP case?
Your Honor, the state will be presenting either a decline or not presented to the grand jury in that case.
It'll get wrapped up today as well.
Yes,
Great.
sir.
So Mr. Humphrey is here. Is he up? He's here. Great. All right. Danny Jones. He's here. Hey, Mr. Jones.
There he is, Your Honor. We expect this to be a plea today. Ms. Feely and Mr. Jordan has worked things out. I just want to talk to the client.
Okay. Mr. Jones, you may not have met Ms. Primovic before. You may have, but she is a colleague of Ms. Feely. Ms. Feely couldn't be here today, and so Ms. Primovic has graciously agreed to handle all those cases. She just wants to touch base with you. It sounds like your case is resolving today. Ultimately, of course, that's your decision. So please wait till I finish calling the calendar, and then you and Ms. Primovic will talk, okay? Tyler Montgomery.
Good afternoon, Judge.
Hey, Mr. Hood, where's your client?
He should be arriving shortly, Judge, if he's not there.
Okay, we'll hold for his report for a little bit. It behooves him to be here, given the seriousness of his charges. How have you been?
I've been well, Your Honor. I'm not certain if Your Honor has received my motion for continuance, Judge, in this case.
I did. I reviewed it, and we'll talk about it. I want your client to be here for that as well. I'll tell you my initial reaction, but I'll let you articulate it more once your client is here. is that your higher calling is as Mr. Montgomery's advocate and not as the prosecutor in Marietta. But we'll see what the state has to say, and most of all, we'll see if Mr. Montgomery shows up for court. You may be able to do both things because Mr. Montgomery will be in the wind, and you can be doing what you need to do in Marietta.
Your Honor, I actually am sitting outside the city of Marietta about to begin a 1:30 court session. So may I make my request at this moment and allow my client to come in once he does arrive?
So sure, my guess is you're not going to be able to do anything to stop your client from coming in. Why don't you tell me what you want to tell me, and we'll hear what Mr. Jordan has to say, and then I will wait to see if Mr. Montgomery makes it.
Your Honor, I am, as my motion articulated, the assistant prosecutor in the city of Marietta. The actual prosecutor underwent heart surgery last Friday. He is out for the next 4 to 6 weeks. I have been exclusively assigned to handle both sessions, Wednesday and Thursday, for the next 3 weeks. So respectfully, Judge, I'm asking for a one-time continuance of this matter such that I can handle my prosecutorial duties over in the city of Marietta.
Okay, I hear you, and that's what you put in your motion as well. Mr. Jordan, is the state ready to go forward in Mr. Montgomery's case?
The state is ready, Your Honor.
All right. So, Mr. Hood, I won't keep you from today's batch of prosecutorial matters that you're going to go cover, but I'll let you know via that email if Mr. Montgomery's on the will call a Monday morning list or not. I want Marietta's prosecutions to go forward, but I also want my cases to go forward, and I know who came first on this one. So we'll see how it plays out. But go do what you need to do for today, and maybe say a little prayer that Mr. Montgomery's on his way.
Yana, also, I have been called into trial on report back calendars on 4 calendars in Cobb Superior Court. I expect at least 3 of those cases to resolve short of trial. There is one case at trial. I need to see which case is older between Mr. Montgomery or this case, but I have filed the same motion for continuance in that case as well. But I will look forward to Your Honor's email and respond accordingly. I may see you on the 27th if that's what Your Honor requires. But respectfully, again, I'd reiterate my request for continuance.
Got it. Okay, you're juggling a lot. Thank you for your service.
I am, Judge. Thank you so much. Have a good day, Judge.
All right, bye-bye. Don't let me forget about Mr. Montgomery. I may not remember to call it again. I'm gonna make a list. Christopher Coleman is here.
I spoke with him at the beginning of the calendar. We have an offer. Ms. Feely has talked to him. The same, Your Honor. I would like to talk with him also, but this should work out today.
Okay. And you heard me, Mr. Coleman, explain to the other gentleman, Ms. Prinovic works with Ms. Feely. She needs to talk to you to see where you are with things, and it may be we sort your case out today. So please don't go anywhere until I say it's okay to leave. All right? Thank you. All right, Mac Ransom pled. Raymond Carter. There he is. Ms. Rockwell, good afternoon. Mr. Whitenauer, your case. Is the state ready to proceed with Mr. Carter's case?
Judge, in this moment, no. The witness and victim in this case, Ms. Tita Woodard, was served with Rule 9-SI documents this morning in Pensacola. She's to be at Superior Court in Escambia County this Friday at 11:15. And she can then either have a hearing on this matter or waive, provide all that to the state's attorney in that county. So I'll have a better sense of whether the state will be ready come Friday afternoon. But in full Canada court right now, I'm not ready because she's not been served with the subpoena.
I'm confused. What did she
Well, she's been served with the rule nisi to appear in court.
Got it. Okay.
To have that hearing.
So she'll go to court in theory. And that's when the judge can say there are a number of options, one of which is a trip you have no choice on, another would be voluntarily, et cetera. Okay, got it. I knew that was in the works. I just wasn't sure where we were in the process. Ms. Rockwell.
I was on leave, Judge. I filed a leave probably last year for the 28th through the.
Oh.
I was trying to hurry up and look it up. I didn't look at it with my eyes. My paralegal did confirm that I filed a leave.
All right, well, we'll look, but your leave covers at least Monday. Monday is when we're picking a jury. So if you're not here on Monday.
It starts February 24th and through March the 7th.
Okay, that sounds like a nice long leave. Where are you going?
Probably nowhere.
Probably nowhere. You're not going to court is where you're going.
I just lie to myself and tell everybody I'm going on vacation and I'm coming to the courthouse anyway.
Where do you see it?
I see. Well, it's under.
And I didn't see it, Judge, but my paralegal.
What date?
March.
But what's the date she filed it?
September 20th, 2022.
Oh, look at that. Okay. Along with her, you filed your entry at the same time you filed your absence. I guess that's smart.
I try to get it all at the same time.
February 24th through March 3rd. 24th through the 3rd. Well, all right. That would be all of next week. So what does that mean for what's the last name?
Woodard.
Ms. Woodard. She doesn't need to remain in custody until the next trial. It might make it easier for you, but no one's going to keep her in custody till the next trial calendar. I remember Mr. Carter, boy, he's not working this case out. He's going to trial, which is his right, which means you'll need Ms. Woodard. How do we do this next time so that you've got a little more breathing room to make sure that she's coming, whether it's voluntarily or not?
Well, Judge, as soon as I get the next calendar, I can then work on having her served again for those dates. I think now that she knows that we know where she lives and that we have a way of contacting her, she might be more cooperative and speaking to us.
So she'll either move again or she'll get it that she's within your reach.
Yes.
Okay, so last trial calendar, maybe you didn't even have this address.
I didn't.
Okay, so this is an improvement in terms of your ability to reach out to her.
It is. When we first began searching for her using all the tools that we have, her address was not popping up, but those systems found her and we got her address.
Got it. I need to honor Ms. Rockwell's leave of absence. Mr. Carter's on bond, so the imposition on him is just that these charges remain, but he's not in custody. Will you please let Florida know, you'll manage it as you see fit. It may make sense in your mind to have Ms. Woodard show up to court. I don't want to waste that court's resources because now we don't need Ms. Woodard for next week. And maybe the message has already been delivered with the service.
I'll communicate.
Thank you. Okay. Mr. Carter, we got to move your case to another calendar. You remain on bond. Make sure you comply with all those conditions of bond, okay?
Yeah.
All right. Hope it's better than that. Yes.
Thank you, Judge.
You bet.
Your Honor.
Mr. Matthews. Yes, sir.
Good afternoon, Judge. Carrington Matthews here on behalf of Mr. DeAnthony Brown. I wanted to announce to the court that I'm actually in trial and
oh, okay. Thank you for flagging that, because then you need to get back into a courtroom.
Well, we start back up schedule for 1:45. I am in the building. I'm before the Honorable Earl Glanville. So I'm in that case. So I have a resolution worked out with the prosecutor. I was hoping maybe we could resolve Mr. Brown's case this afternoon if they were able to make him available. I think he is in the Fulton County Jail.
So sure. So pause for 1 second. You are now in the YSL case, or you've always been in the YSL case?
I've always been in the YSL case.
Wow, I didn't realize that. Huh, how's that working with business?
It's working, Judge. I have a little help. I've got some team members we're working together on our client's case. So we're navigating it.
Okay. Let me find out. Is Mr. Brown, that's position 20, is he here?
Yes.
Okay. So what you're saying, Mr. Matthews, is that that's a plea. You may need to duck back into court, but you could come back out to take the plea, or you want to do the plea now. It'll probably get you a little past 1:45, even if we started right now. But if you disappear for the rest of the afternoon, I'd rather do the plea now.
We can do it now, Your Honor.
Do we need to reach out to Judge Glanville to let him know you might be there more at like 1:55?
I have some coverage.
Okay. Can I call just a couple more positions on the calendar and then we'll do Mr. Brown?
Thank you, Judge.
Okay, thanks. So Cody Polio was a plea, and that gets us to Kenneth Hill.
Good afternoon, Judge.
Hey, Mr. Shapiro.
How you doing? This is my case. Karen Pass represents Mr. Hill, who's in custody. I have not received a notice of conflict for her and did not see her in the courtroom, so I'm not sure if she's on the Zoom call or not this afternoon.
Ms. Pass, or someone from Ms. Pass's office, are you on the Zoom call? All right, we'll reach out to her because this would be right up there with Ms. Grant, because Mr. Hill's actually in jail, been in jail for now over a year. So that would be on my short list, assuming your announcement is ready.
We do have an announcement.
Other than ready?
Subject to one caveat, which is that we have a number of out-of-state witnesses that are appearing for the trial of this case. So rather than being placed on the short list, we did file a request to have this trial specially set since we have out-of-state witnesses who need to appear. We've obtained waivers from several of the witnesses. However, interstate compact may still be an issue for at least one of them. We can address that when Ms. Pass arrives, though, if we need to.
Got it. So you're ready. If you're on for next week, you'd like to be number one for next week rather than number three, because then there's certainty that you're going out.
We do have one of those out-of-state witnesses who's on pre-approved leave for next week. That was the other caveat of our request for a one-time continuance and a request special set. One of our law enforcement officers.
Won't be available.
Will not be available the week of the 27th.
Okay, and he or she plugs in how? I'm familiar with the case because of evidentiary hearings we've had.
He is the officer who provides a photo lineup to one of the juvenile victims in which she makes an identification.
Okay, got it. So you'd be hoping we could do this at a different date so that that officer could be here?
We'd be ready for whatever the next trial calendar is, and we can have all of our witnesses here at that time.
Especially if it's specially set?
Correct, Judge.
All right, we definitely need to hear from Ms. Pass then, given that Mr. Hill's been in jail for so long. She may say that's not her problem. So we'll reach out to her if you don't mind sticking around.
Of course. Thanks, Judge.
Sure. Mr. Stewart was null prost. Darian Peters.
Judge, he's my client. A second evaluation was filed on January 5th. I reached out yesterday to see if there was an update on maybe when we could expect results. And I have not yet heard back from court services.
So that's pending.
It is.
And it was a second evaluation because you didn't agree with the first, or because things have changed? The first was 2 years ago and it's time for a refresh.
The first was last year, I believe around summertime, and we didn't totally agree with the results, but Ms. Patterson and I thought we might be able to work through it. And
It's not happening.
no,
Okay, so we couldn't do anything on Monday with this anyway. We need to get another expert opinion. If it continues to be competent as the opinion, then you're going to need to figure something else out. We all will, but we need to get those results first.
yes, Judge.
Okay, Mr. Jordan, I think what I'll do is divert this to an inquiry calendar in the future. Any objection to that?
No, Your Honor.
All right. And I've signed whatever I need to sign. You're not waiting on orders from me. It's getting Emery or Grady to do what they need to do.
Correct.
All right, thank you. Emery Batten, I think this was re-indicted, Mr. Hiles, is that correct?
It's waiting on his case number. We added 5 incidents, and
How many defendants did we add?
I did not add any defendants.
Okay.
But I did put an additional one on his co-defendant, Ricky Wolf.
Ah,
And I put an additional one of the cases that was in judicial hold for Mr. Wolf. I added that to this.
so is Mr. Wolf now a co-defendant in this?
Mr. Wolf on the indictment that's on this calendar, he is actually a co-defendant already.
Oh, he's already there. So I don't have it in front of me, but the indictment ending in 513 right now has Batten and Wolf.
Correct.
It's been re-indicted, and once you know it's legit and it's in there, you can null pros this one. The re-indicted one still says Batten and Wolf. You've pulled a Wolf case into it, added maybe some other things, but it's still Batten and Wolf. Okay, and Wolf, his case was on judicial hold. He's not in the wind. He's
not in the wind. This particular case, he's actually charged with murder.
Right.
He's not in judicial hold. However, his attorney, Anastasio Nettis, is on the YSL case. And he is on the trial calendar for June. My preference would be to try them together, but I do understand that if this case drags out, that might not be.
okay, but we have a refresh anyway because there's a superseding indictment. Ms. Wood will need to get that, get the additional discovery for her, and we got to arraign Mr. Batten on that. In theory, we have to arraign Mr. Wolf on that too, but we can manage that. So this is off.
Yes, and I think I've been talking with Ms. Wood. I think what has been added for Mr. Batten makes the stage case stronger, and I'm hoping that we can resolve.
But it's not adding murder type charges for Mr. Batten. Okay, all right. Ms. Wood, what's your thought about what we do next in Mr. Batten's case?
Judge, did I understand correctly that you said Ricky Wolf is already on a June trial calendar? Is that what
He
you
is.
said? Okay. So,
For this case?
Yes, this 22, the case that Mr. Batten's on, Mr. Wolf, when I looked him up, was on your June trial.
Okay, so we could,
Like track them together.
yeah, and we ought to, and then it may be that we decouple Wolf and Batten is, as you said, ideally you try them together. We'll see what happens with, what's the lawyer's last name?
Menettis.
Mr. Menettis, and his participation in the YSL case. Maybe Mr. Matthews can cover for him while he does the trial for Wolf. But why don't we plan on having whatever number this reindictment gets moved to the June trial calendar?
yes, Judge.
Okay, when can you null pros the case ending in 513?
As soon as I get the number, I'm gonna go talk to them.
Okay,
And,
so it's that new, there's not even, I guess Ms. Nelson told me that, there's not even a number yet, so, okay. All right, reindictment, further notice, June, with Ricky Wolf, the gift that keeps on giving. All right, thank you. We're almost to Mr. Matthews' client. Fernando Price.
Judge, this is my client. We have a negotiated resolution. There's one minor hiccup. Mr. Jordan and I are trying to iron it out. I'm hoping we can get the plea done today. It involves the housing aspect of his program placement.
Okay, we'll see, but it's resolved. It may just not be today.
Yes, Judge.
Okay, so it shouldn't go on the list for Monday.
No, Your Honor.
Okay, all right. Maurice Jackson has 2 cases. Both are Ms. Primovic's. One is Mr. Jordan's, one is Mr. Whitenauer's.
We're working on that, Judge. We're hoping to maybe have a resolution today.
Everyone looks at everyone else. My recollection is that it's the Whitenauer case that drives it. Okay,
We gave a counter offer and he's thinking.
Yes.
still thinking?
Yes, I'm still thinking, and I won't say pre-trial judge, but I'd like to speak with her before trial.
Discussion?
Yeah.
Okay,
Discussion.
all right, I'll put that over here. All right, that gets us, Mr. Matthews, to Mr. Brown. Is there anyone in court who's got a quick announcement that we could handle so they can leave before we take the plea?
They're about to take my case. I'm gonna hit you and give you some more instructions. Just sit tight, okay? Cool. I ain't you back.
Hey, Ms. Olivier, how are you?
How are you?
I am well.
I have position 25, Jamil Lewis. I know we spoke about this one about a couple of weeks ago. The ballistics report is still pending in the case, and we should have it back by the March 27th trial calendar, so we would be ready at that time.
And I believe Ms. Feely had said that's okay, as in she's not objecting to bumping it one. Is that still okay, great.
I think there's DNA, maybe even there's a few other more else.
There are some things pending, but we should have everything by March.
Okay. So if there's room on the March calendar, Mr. Lewis goes there. And you'll let Ms. Feely know that. If Mr. Lewis, do you need to speak with Mr. Lewis or can?
I have one little thing I need to tell him.
Okay.
She thought a bond was boring.
Okay. All right. Well, that's how we'll handle that. Thank you.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
Judge, March 26th, is that when you potentially or?
I'm not, maybe, I don't know the specific dates, but we'll let you know. All right, sure. So when you're ready, if we can bring Mr. Brown out.
Your Honor, may I please be excused?
Yes, sir. Go get that indictment number.
Yes, sir.
Then I think you've exceeded your indictments for the year. Great work. Yeah. Go try something instead.
Bronner.
I got this,
Mr. Matthews.
What floor are you on?
I am on the 8th floor, 8D as in Delta.
Can I just come up?
That'd be easier. I got Mr. Brown right here. I bet he'd like you to be by his side. Come on up.
Let me come up. Thank you.
Okay. I was waiting for him to suggest that. Mr. Brown, that was your lawyer. He's in the building and he's on his way up. And he tells me that he's worked out a plea for you.
Okay.
Hopefully that's not news to you.
No, it's not.
Okay. Ms. Rivers, are you ready?
Yes, I am ready.
Great. Pardon? Mr. Jordan, is this a plea to the charges as they are? Are you modifying anything?
Only to count one, Your Honor. The state's going to dismiss the fixing materials windows.
The tint charge?
Yes.
Okay. Well, while we're waiting, Ms. Wood stepped out. Do we have any other defense attorneys in here? I thought we could take another. How about Mr. Whitenauer still here? Mr. Kane? I see you on there.
Your Honor, I'm here, but I'm not here for Mr. Kane. I did see him on here as well, but
Mr. Kane's here. Here I come.
Great. Why don't we get the announcements? Because we've got Mr. Whitenauer here for your two clients. Is Ms. Diaz-Ortiz here?
Your Honor, she is on Zoom.
Uh-oh. Next time, come to court.
Your Honor, part of her bond condition is that she stay in Pennsylvania where she lives.
Oh, don't come to court.
And so
All
I didn't want her to come unless we needed to be here.
No, thank you. There she is. Okay. Ms. Kaufman, are you ready to go forward with Ms. Diaz-Ortiz's case if for some reason the state can't figure out how to resolve it?
Yes, but my hope is that we can resolve it.
Okay. Mr. Whitenauer, are you ready on the Diaz-Ortiz part of the Pitts Diaz-Ortiz case?
Yes, I can be ready on that.
Okay. And let's turn to Mr. Kane. Mr. Kane, are you ready to go forward with Mr. Pitts?
Well, not really. If I could just tell you what's going on. to
You
explain
can.
my answer.
Okay.
Okay, so the district attorney and I have been trying to figure out a resolution. And we have followed the court's order since the calendar was published to try and come up with a plea recommendation. And I know John has been trying to reach the purported victim and has been unsuccessful, and so have I. Now I've tried to reach her and I can't find her. So I'd ask the court to put it on an inquiry calendar to see if this complainant, this purported victim, is still in the loop or not. And if so, then we can work out a plea.
Mr. Whitenauer, it's a little unorthodox, but we're dealing with Mr. Kane, so this doesn't surprise
So
me.
roll with it.
Yeah, I don't like the bluff game anyway. If I were to call this out on Monday and you can't track down, as I recall this would be Mr. Pitts's ex, gun to her head.
It's the child's mother who's gone back and forth on what she wanted to do.
I understand, and I'm hearing from Mr. Whitenauer now, but I'm just remembering from a bond hearing the allegations in this case. But if we were to have this go out because Mr. Pitts has been in jail for a long time now, and you were going to have to beg for a continuance on Monday because you don't have her, where are we? Or do you agree with Mr. Kane that maybe that's what we ought to do, is have an inquiry calendar and see? I'm not requiring this person to show up in front of me. And frankly, she doesn't have to talk to Mr. Kane if she doesn't want to, but he at least needs to have had that opportunity so she could say, no, thank you.
Yes, sir. So we have in the past had communication with the victim in this case. And it is true, as is common in DV cases, that she has gone back and forth.
Right.
But as for this trial calendar, we began attempts to reconnect with her in early February. This has not been successful yet. But at the same time, we haven't really mounted a full court press to bring her into court. And if this is a trial, we'll do so. We're miles apart in terms of plea negotiations.
For both defendants?
No, for Pitts.
Okay. What I want to avoid is making Ms. Diaz-Ortiz come all the way down here from Pennsylvania, only to find out on Monday that you're not ready to go forward. I might not make you go forward, but then I might have to think real seriously about setting a bond for Mr. Pitts if he doesn't have one, or making it more obtainable if he has one that's too high. And so maybe the middle ground is what Mr. Kane is describing, which would be to set this out for an inquiry calendar, at which time you would report with, yep, in pocket, and she's told me she'll want to talk with counsel for Mr. Pitts, and that's all on the record. And so Mr. Kane could use that in cross-examination, et cetera. But that way we'd know that we've got the pieces we need before Ms. Diaz-Ortiz comes down here, either as a defendant or potentially a witness. And I would foresee her being involved in one of those two ways. So how does that, I assume, Ms. Kaufman, you're neutral as long as your client doesn't need to come down here for a pointless calendar call.
That would be accurate.
All right. And Mr. Kane, I guess I'm saying yes to what you requested.
Yes, sir. Thank you. And also to the ADA, we can both put the full court press on to find this woman to see what her position is, if any. So I'd ask John to move the ball down the court, and I will also.
All right. What I'm going to do, because we now have Mr. Matthews here, is take this under advisement. I will put this case on the email that you'll get today or tomorrow if it's shortlisted for Monday. But it sounds like there are reasons not to do that, that are good reasons. So really it will be driven by how likely am I to have something to try on Monday. So I will let you, all three lawyers know, and then you, of course, will let your clients know. All right. Thank you for being here. You all are free to go.
Thank you.
Thank you.
Good day.
Yep. All right, Ms. Rivers, if you're ready, we now have everyone we need in here in court.
Okay, I'm ready.
Great. Let me get that podium spotlighted. Excellent. Well, let's get on the record. Position 20 is State versus Brown, 22 SC 182797. Mr. Brown is here in court. You've been at Cobb for a long time, but Blue says you're at Fulton. Did they move you from Cobb to Rice Street?
Yes, sir.
Okay. Which did you prefer?
Either.
Neither.
Neither.
Okay. Well, that's probably why you're standing here right now. Mr. Brown is standing next to his lawyer, Mr. Matthews. We've got Mr. Jordan ready on the prosecution side. Mr. Brown, Mr. Jordan's going to put you under oath. Once you're under oath, please answer his questions truthfully and completely. Also, please let your lawyer or me know if you've got any questions. Will you do that?
Yes, sir.
All right, Mr. Jordan.
Mr. Brown, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
D'Anthony Martez Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been taking today?
No, sir.
How old are you and how far have you gone to school?
33 years old and 12th grade. I didn't complete it, but I went.
Understood. Are you able to read, write, and understand the English language?
I am.
Do you understand that you have been charged with the following offenses? Count 1 being possession of firearm by a convicted felon, and count 2 being a window tint violation?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Mr. Is it Carlton Matthews?
Close, Carrington.
Carlton, my apologies, Mr. Carlton Matthews, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Are you satisfied with your services?
I am.
Do you need any more time to discuss the case with you?
No, sir.
Mr. Matthews, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Brown's name?
So waived.
Mr. Brown, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is not aware of any outstanding warrants that are related to these charges. Mr. Matthew, do you know of any outstanding warrants related to these charges?
I know of none.
Can you bend the microphone towards you, please, Mr. Jordan? Yeah, that's okay. Thank you.
Mr. Brown, has your attorney advised you the minimum and maximum sentence for each charge that you're pleading to?
He has.
And Your Honor, just for the record, the state is going to dismiss count 2, which is the window tint violation. As for the possession of firearm by a convicted felon, that has a minimum of 1 year and a maximum of 10 years. Mr. Brown, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as to count 1, possession of firearm by a convicted felon, the state's recommendation is 5 years to serve 1, commuted to time served. Mr. Brown has been in custody, the last that I looked, 289 days. This was an offer that was previously extended by the now departed ADA Pierce Hand. He actually extended the offer of 5 to serve 1 without it being commuted to time served. But that was a few months ago. Given how close Mr. Brown is to being a full 365 days, the state felt fine extending the 5 to serve 1 commuted to time served. And of course, with the balance being probated. Do you understand that the court does not have to accept that recommendation, Mr. Brown?
Yes, sir.
Do you understand that this court can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit without being subject to revocation for the balance of the sentence?
Yes, sir.
And I did not have any special conditions to add on, Your Honor, but if there were any special conditions that were added on, if you violated those as well, you would also be subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction just as there would be from a conviction following a trial.
Yes, sir.
Do you understand that your guilty plea may affect the following: your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify and remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Brown, how do you plead to the sole charge of possession of firearm by a convicted felon in indictment number 22 SC 182797?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Mr. Matthews, have you advised to Mr. Brown all of his deadlines for filing a direct appeal?
I have.
And Your Honor, for a factual basis, on May 12th of 2022, APD officers were on patrol in the area of 10 Ormond Street, and that's ORMOND, when they noticed a vehicle with a window tint violation. They did conduct a traffic stop. According to the officers, the transmission rate of the glass was at 2%, well below the 32% rate required by law. The officers did make contact with the driver, the defendant, Mr. DeAnthony Brown, and they asked Mr. Brown if he had anything in the vehicle that they should know about. Mr. Brown did advise that he did have some marijuana in the vehicle, gesturing towards the center console. Mr. Brown was then detained and the vehicle was searched. Some marijuana was found. They also did find a handgun in the center console that was located inside of a baby bag. The weapon was found to be stolen, but they interviewed Mr. Brown and he stated the gun was a recent purchase. Your Honor, that concludes the factual basis. As far as the marijuana goes, it was never tested. And also, my office did not believe that there was sufficient evidence to that Mr. Brown knew that the weapon was actually stolen. So there was originally a theft by receiving stolen property charge as well, and it was not presented to the grand jury. Your Honor, given the amount of time that Mr. Brown has spent in custody, I believe I agree with ADA Hand, or the previously ADA Hand, that this was a fair negotiated resolution, and we just ask that Your Honor accept.
Okay.
And my apologies, Your Honor. They also, of course, found Mr. Brown to be a convicted felon with his conviction coming from 14 SC 125586.
Okay, I see that. I noticed he was a repeat offender, and so that's why the case got bounced here from non-complex.
Correct.
Okay. Ms. Mann, good afternoon.
Good afternoon, Your Honor.
How are you?
I am doing well, and you?
I'm well also. So I've got a little bit of Mr. Brown's criminal history through the repeat offender notice that shows 7 felony convictions. Can you tell me number of cycles? And the most recent conviction I've got was something out of Coweta County for criminal damage to property. I'm wondering if you had anything else like that.
Okay, let me look at it. Starts at the top, but let me go to the bottom for you. That would be no problem. There are 33 prior arrests, Your Honor, but I am looking for that most recent. As I said, mine started from the top, but let me go to the bottom. I do have it's a probation violation, Your Honor. From Georgia, from Fulton County Sheriff's Office. It is for probation violation for a fingerprintable charge. It did not give me that one. That one, however, Your Honor, is a misdemeanor charge for probation violation that was convicted on 10/16/19.
Okay.
It does not give me the stipulations for that through GCIC, Your Honor.
Okay.
Let's see. We'll keep going back. I know you wanted the most recent ones. I'm at 2018 going backwards.
No, that's fine because 2018 is something that I've already got. So you cleared it up. All right. Thank you.
You're welcome.
Mr. Matthews.
Yes, Your Honor, I'll be very brief with the court. D'Anthony Brown, like the government has indicated, is 33 years of age. He has 3 children. He has an 11-year-old, a 4-year-old, and a 1-year-old child. Prior to his arrest on May 12th, 2022, he was a forklift driver driving for a company called Capstone Logistics. Your Honor, with respect to these events that took place back on May 12th, 2022, it was a very uneventful traffic stop. He was compliant. He did not give a false name, did not try to resist or take any efforts to prevent law enforcement from doing his job. In fact, he was forthright with them with respect to a small quantity of marijuana that was located inside the compartment of the vehicle. There was a firearm. Mr. Brown acknowledges that he was in possession of this firearm. There had been a number of violent incidences that occurred in his community, in his neighborhood, up on the block. And he just really felt very fearful for his own safety, the safety of his girlfriend, the safety of his small children. So he made a decision. That decision has landed him in custody here since May 12, 2022. So he recognizes that that was not the wisest decision to make on his part or the part of his family. Notwithstanding that, Your Honor, he is remorseful, he is contrite, and he understands the nature of the consequences that gave rise to this charging document. We're asking the court, Your Honor, respectfully, to accept this negotiated resolution. He's done time for it. We believe that the amount of time that he has done has been negotiated with the government. We're asking the court to follow it. We do believe that Mr. Brown, if the court follows it and he's released, I believe he'll be compliant with probation. I'll ask that the court follow it and allow Mr. Brown to move this chapter of his life to a new chapter and get forward with his other responsibilities that he has for his family and for himself.
Okay. Mr. Brown, anything you want to add?
No, sir.
3 kids all in the same household? Like when you go back, will you be with all 3 or are they in different places?
I'll be with 2 of them.
Okay. The youngest ones?
The 2 youngest.
Okay. And you have a place to go to when you're released?
I do.
And where's that?
311 Scott Street, Atlanta, Georgia, 30311.
Okay. And is that where the mother of your kids lives?
Yes, sir.
Okay. Does she work?
Yes, sir.
What does she do?
She works for Humana call center.
And are you able to go back to this forklift job or you'll need to find something different?
A couple of months ago, I was able to. I haven't spoken to him since then, but I probably could if I could just give him a call.
Okay. Is someone you know?
Yeah.
Okay. All right. Any questions about anything?
No.
Okay. Well, Mr. Brown, I find there's a factual basis for your plea. You were driving a car, maybe had a little too much tint on it, regardless of whether it did or not. There was the gun in the car, and that was the thing that got you where you are. You have a bunch of felony convictions, and you can't have a gun. You may feel like you need to have one, but maybe you should have a crossbow or an axe or something else. But if you get a gun and you get picked up, this is just going to repeat itself. And presumably, I won't necessarily be the judge. It'll be a little bit more time each time, unless the law changes on felons being able to have firearms. I also find that your plea is knowing and voluntary. Voluntary means you've understood everything. Knowing means you've understood everything we talked about. Voluntary means no one's forced you to enter this plea, but after consulting with Mr. Matthews, you've decided that's in your best interest. Is that correct?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor or a technical violation, you and probation work through that. You don't have to come see me. But if you get arrested again, no matter whether it's for a gun or something else, that comes back to me and we'll work through what the consequences should be. Okay. Mr. Brown, do you authorize my staff to sign the indictment indicating your guilty plea?
Yes, sir.
Mr. Matthews, can we sign for you?
Yes, Sean.
And Mr. Jordan?
Yes, sir.
Mr. Brown, I'm going to sentence you on count 1 to a period of 4 years to serve 10 months with the balance on probation. You'll get credit for all the time you've done. You may not have quite done 10 months, but you'll get out at a maximum at the 10-month point. You're not going to get sent to the Department of Corrections, and the sheriff may well look at the math and say, let's get Mr. Brown out tomorrow. But I think that it is a better fit to have a sentence that is defined rather than reduced to time served. I also don't think you need to be on quite that much probation. If there's going to be an issue, we're going to see it sooner rather than later. As you get older and more responsible for your family, hopefully you'll be less likely to get caught up in a situation like this. You got into 12th grade but didn't finish high school?
Yes, sir.
Do you have your GED?
No, sir.
Okay. Are you interested in getting your GED?
I am.
Would it help you with employment?
Yes.
Okay. So a special condition of your probation, the only one, will be that you get your GED. You don't have to do that day one, obviously, but you'll need to be enrolled, and probation is going to be bugging you to make sure you're passing these tests or you're doing all that. So 4 years to serve 10 months, balance on probation, credit for time served, special condition of probation, get your GED. Count 2, the state has dismissed. That should be everything. Mr. Matthews, anything else on behalf of Mr. Brown?
Your Honor, I would respectfully ask the court to reconsider making the GED requirement a special condition of probation. When Mr. Brown returns to society, his first and foremost responsibility is going to be to get a job and work on taking care of his family.
You're right. I don't mean for the GED be a tripwire in any way. I'll make it a condition of probation. And the difference there, Mr. And I'm sorry to interrupt you, but I agree with you. I know you've got somewhere else you need to be. A special condition, if you violate that, I can revoke all your probation. A general condition, then if you violate it, you're not getting your GED on time, I can fuss at you some, I could revoke a little bit. Frankly, I'm not interested in revoking you if you're not getting your GED. What I probably would do is say, well, great, I'm gonna make you do something you don't want to do. Go do community service or something like that. But it's a fair point. And so it will be a condition, not a special condition of your probation, that you get your GED. I hope you get it. I hope you are encouraged to get it, but you got 2 immediate little kid mouths to feed. I'm assuming you're on the hook for kid number 3 as well. And you're going to want to hit the ground running as much as you can. And so get the GED, but I don't want that to be a distraction. That wasn't my point. So well taken. Mr. Jordan, anything else?
Nothing further from the station.
All right. Okay. That's it.
Thank you, Your Honor.
You're welcome.
All right.
We need, our defense attorneys are back. You're just sitting in funny places. Did you have an announcement, or can I keep working through the calendar? We're almost done, and then we can take whatever pleas or whatever we're going to do.
I'm sorry, Judge.
Sorry, we're on position 21, which is Ms. Edwards, which is your client.
Judge, she is also, I think she's the last position as well.
Take care, Judge.
Oh, look at that. Yes, good luck down there in 1C for the next 8 months.
Or longer.
Okay, is Ms. Edwards here?
She is.
She is. Look at that. You do have 2 cases. Okay.
Judge, if she could stick around, I'm still negotiating with Mr. Jordan on this one.
Okay. It's interesting that she got a bond on the second case, given that she had the first case, but one came from non-complex and it looks like was particularly, well, these are both, okay, the old conduct. It's from 2020.
Yes, Judge.
All right, so Ms. Edwards, you need to stay where you are and Ms. Wood's gonna come talk to you, okay? 21. 30. All right, we already talked about 22 and 23. Nicole Roberts is position 24. There's Ms. Roberts. A plea, all right. Your timing was perfect. She walks in, that's a plea. Position 25 has been continued. Position 26, Craig Owens. Right there.
Judge, we're still working on this one. I'm hoping to have a plea today.
All right. 26 discussions. You guys, next time I'm going to say there's no pretrial, there's no discussions, but just because you don't say pretrial doesn't mean I'm not annoyed. All right. Talk about Mr. Owens's case. Mr. Hurd.
Your Honor, that's mine for Mr. Harvey, who is, well, in the YSL case.
Okay, let me get you. There you are, Mr. Katz. Thank you for, I think you were probably here last time we called Mr. Is Mr. Hurd here?
Your Honor, I believe he's by Zoom, and I think that's my fault, and I apologize.
That's all right. Is he the Zoom user? Which one is Mr. Hurd?
Mr. Hurd, if you would identify yourself.
Is he the guy with the shower cap on?
Mr. Hurd, would you raise your hand?
We'll see. We got it right there. Wave your hand. Is that you, Mr. Hurd? There we go. Mr. Hurd?
Yes, I'm having trouble hearing on my phone.
Okay, we can hear you just fine now. So where are we? This is a case that has been around forever. It's gone from murder to involuntary manslaughter. Maybe Marta's going to be sued. What's the latest?
Well, Marta has been sued. That's pending before Judge Schwall.
Okay.
Your Honor. Mr. Hurd, of course, is out of jail. Mr. Harvey, for lack of a better term, is somewhat in jail in the YSL case. That is, he is somewhere he doesn't want to be and is not free to leave.
And is he lead on Mr. Hurd's case? You are graciously standing in for the calendar call, but you're not co-counsel?
Co-counsel, he's lead. You know, he's lead on everything he does. So
he is, but that doesn't mean we couldn't move forward with Mr. Hurd just because Mr. Harvey fancies himself as the lead of everything.
Well, that's true, Your Honor. And that was done last year to me in DeKalb County. However, I would argue and request that the court continue it just this calendar, and so that Mr. Hurd can speak with me and consider what his options are if Mr. Harvey's unavailable and you're inclined to say, hey, you're next up.
Okay, let me hear from Mr. Whitenauer. Your thoughts on how we ought to move Mr. Hurd's case forward.
Judge, it is an old case and we do need to move it forward. But I have been focused on some earlier cases in the calendar. If you're on the best places on the short list, I'll be ready.
Okay. All right. Mr. Hurd, were you able to hear what everyone was saying?
Yes, sir.
Okay. Are you on a conveyor belt in that locker room?
I'm at a job fair.
Okay.
I just ducked into the bathroom.
Okay. All right. Mr. Katz, you have good contact information for Mr. Hurd?
I do.
Okay. So if I need everyone to come in on Monday, you're able to reach him?
I am.
Okay. All right. I'm going to ponder this one as to whether it'll be on the short list for Monday or not. And you'll know, and we'll go from there. Okay.
Yeah, Your Honor, I am under a court order to appear in Upson County Monday. It's a civil matter, but there is an order directing me to appear and directing my client to appear at a deposition. I have an investigator who's also appearing. It's quite expensive.
Okay.
And so notice sooner rather than later would be helpful.
Understood. No, I won't sit on this one because everyone needs to know how to arrange their next few days. All right. Thank you, Mr. Katz. I appreciate it.
Thank you. May I be excused, Your Honor?
You may. Mr. Hurd, go get a job.
All right, thank you, sir.
Yep. Zuriel Anthony. We did something recently with the bond in this case. And now I may regret it. It may have been like taking the ankle monitor off or something. Was it just switching it to county paid? Any notes you've got, Ms. Primovic, about why? Yeah, so I modified the bond about a month ago, saying didn't need to wear the ankle monitor anymore. Oh, phooey. Okay.
Oh, he still wouldn't be here. We just would know where he was.
And with him not being here, they'll move for bench warrant.
So Ms. Nelson and I had a good conversation yesterday about bond forfeitures. And then I had a good conversation with another judge who has done some of those recently. At a minimum, please do the paperwork for a bench warrant. And I'm all for a bond forfeiture, but there are time-sensitive hoops that your office needs to jump through. So I'm not directing the bond forfeiture, but I will support the bond forfeiture and execute whatever orders I need to. I think something has to happen within 10 days, and then the hearing has to be within 120 to 150. We'll make that happen if you get us the right paperwork. I created some confusion in a totally different case that's not yours, Mr. Whitenauer, where I said, bring someone in for a bond forfeiture. And that's not what I meant. It's what I said, but I meant a revocation. And here, though, I would like a bench warrant. And if your office wants to pursue the bond forfeiture, let's do it. Freedom Rings ought to have gotten Mr. Anthony here.
Yes, Judge, and it is my practice on the day of the counter to provide a bench warrant to your chambers. And then I also personally prepare the bond forfeiture paperwork, motion and rule nisi. And we do mail that out certified within 10 days of that FTA. And then, of course, Your Honor, your chambers would set that date.
Good. All right.
Ms. Feely is texting him, so hopefully we won't have to do anything.
Sure. No. This is just, I wanted to make clear to the players that bond forfeiture is also okay. Timothy Anderson in custody.
That'll be a plea, Judge.
Oof, okay. And then Ms. Edwards is that last position, linking back to position 21. So did Mr. Montgomery show up? All right, bench warrant and bond forfeiture.
Yes, Your Honor.
Please. Okay, I don't think we ever heard from Ms. Pass. We reached out to Ms. Pass. So Mr. Shapiro, I don't want you to stick around. We'll reach out to you when we hear from her.
Judge, I did, I apologize. I did just review an email that I was copied on that she sent to my investigator last week. I was unfortunately traveling to meet with some of our witnesses in this case. She indicated that she was going to be in a trial. I did not.
Today or next week?
It said next week, and this was sent last Friday, so I assume she may still be in that trial today. I do not, unfortunately, don't have a case number or accounting or any of that information.
But was her email that she'd also be busy next week, or that's just she's busy now?
Judge, I think the email indicated that at least through the end of this week and possibly into next.
Okay.
But
She might want to share that with Ms. Nelson, along with your investigator, but we'll see. Okay, I don't want you to stick around. We'll figure out what we're going to do.
okay.
And I know sooner rather than later because of the moving parts you described and a officer who's on authorized leave.
And I spoke with ADA Whitenauer, and I would just request that if we are to be on the short list at all, given that Ms. Grant is on bond, given that we do have those out-of-state witnesses, we would just ask to go first.
Right. No, I would do that. It's really a Ms. Pass question.
Understood, Judge.
Okay, thank you. All right, I'm ready to take more pleas. Why don't we take, reward our C3 soldiers. Mr. Wilson, you ready?
Yes, Your Honor.
Great. Ms. Edwards? Mr. Jordan, all right if we do that?
Yes, Your Honor.
Okay.
Okay.
So how many cases have you had assigned to you through the program?
So I don't know if I'm technically in the C3 program. I just work for the GPDC and I'm a C3 attorney.
Oh, so you are with I'm blanking on his name.
Arnold.
Mr. Regis. You're with Mr. Regis. Okay. You still have a tough job. Okay. But you are through GPDC's C3 as opposed to our court C3 that we've stood up to take some cases as well.
Yes, I know that they are taking a lot of the conflicts from our.
Taking some, not as many as Ms. Ali would like, but we're taking some and we're happy to partner on that. Well, thank you for the work that you're doing. Ms. Edwards, how are you?
I'm doing okay.
Okay. All right. Ms. Edwards, you've now watched the several pleas. It's your turn. Mr. Jordan's going to put you under oath. Once you're under oath, your answers need to be truthful and complete. And if you've got any questions, you need to make sure you let Mr. Wilson or me know what those questions are. Will you do that?
Okay.
Okay. You don't have to take your mask off if you don't want to, but you're going to need to speak up so that the court reporter can hear you. And Mr. Wilson, if you could bend the microphone towards Ms. Edwards, her words are particularly important to get into the record. This is 20 SC 177-300-303. When you're ready, Mr. Jordan.
And Your Honor, the state is prepared. I just wanted to let the court know this is only going to be a plea to count 2 misdemeanor possession of marijuana less than a month.
Okay.
It's going to dismiss the possession of cocaine.
Got it.
Ms. Edwards, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
It's Anita Edwards.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
Are you able to, I'm sorry, how old are you and how far have you gone in school?
I'm 32, 10th grade.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offense of possession of marijuana less than 1 ounce?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled guilty or not guilty, you would have the right to remain silent and receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Mr. Brandon Hornsby, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Hornsby, do you waive formal reading of the indictment?
So wait.
Is it Hornsby Wilson?
Hornsby Wilson.
Hornsby Wilson, my apologies. Do you also waive any and all defects in the indictment?
So wait.
Ms. Edwards, do you recall having been arrested on these charges?
Yes, sir, I will.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Hornsby Wilson, do you know of any outstanding warrants related to these charges?
I do not.
Ms. Edwards, has your attorney advised you the minimum and maximum sentence for the charge that you're pleading to?
Yes, sir.
And Your Honor, since this is a misdemeanor, the minimum is 1 day in custody and the maximum is 12 months. Ms. Edwards, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state does move to dismiss count 1, possession of cocaine. As to count 2, the possession of marijuana less than 1 ounce, the state's recommendation is 12 months probation. Only special conditions of probation being that Ms. Edwards be subject to random testing and that she consume alcohol or drugs while on probation. I believe counsel will make another suggestion for probation in regards to Ms. Edwards visiting her husband, but I will definitely defer to the court on that particular count, Your Honor.
Are you suggesting she can't visit her husband?
Your Honor, that was a request that was made, and I apologize, counsel. I agreed to it, but I wasn't even sure if that was something that needed to be included.
Okay, I'll hear from Mr. Wilson. That's fine. I just didn't hear you say, oh, and no contact with husband. I heard you say random screens, no alcohol or drugs.
Yes.
Okay.
Ms. Edwards, do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit or any of the special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
And counsel, it's my understanding that she intends to enter a plea under North Carolina v. Alfred, is that correct?
Correct.
Ms. Edwards, are you pleading guilty under North Carolina v. Alfred because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Ms. Edwards, how do you plead to the sole charge of possession of marijuana less than an ounce in indictment number 20 SC 177303?
Guilty.
And is that guilty under North Carolina v. Alfred?
Yes, sir.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a misdemeanor charge, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Mr. Hornsby Wilson, have you advised to Ms. Edwards her deadlines for filing her appeal?
Yes.
And Your Honor, for a factual basis, on September 23rd of 2020, the Zone 1 Crime Suppression Unit executed a search warrant at 899 Beckwith Street in Southwest Atlanta, Georgia. The entry of the search warrant was conducted by the Atlanta Apex Unit. When the officers were able to make entry into the house, there were 4 individuals that were found in the house, including the defendant, Ms. Edwards. They were all taken outside of the location without incident. Inside of the living room, a marijuana cigar was found on the table, along with suspected cocaine. on a piece of broken glass on a mirror. And also there were some marijuana blunts that appeared to have been smoked. There was also a bag of marijuana and $65 cash, along with a pink Apple cell phone with the ID belonging to the defendant, Ms. Nidra Edwards, being inside of that bag. They did speak to all of the individuals. They all refused to cooperate after being given their Miranda warnings. So all 4 individuals were charged with possession of cocaine and possession of marijuana. One of the individuals was given an additional charge of possessing drug-related items. Your Honor, that concludes the factual basis for this plea. The attorney, Hornsby Wilson, and I negotiated this case, and we believe that due to the issues with it being 4 individuals that were in the house and the drugs kind of being in a common era, a jury may have struggled in convicting Ms. Edwards. So we do believe that a misdemeanor plea is an appropriate negotiated resolution. I don't believe Ms. Edwards has any felony convictions. So we would ask that Your Honor accept this negotiated resolution.
All right, thank you. Ms. Mann, how many cycles do you have for Ms. Edwards?
Your Honor, there are 8 prior cycles and only 1 misdemeanor conviction, 609 driving while license suspended or revoked. Nothing further, Your Honor.
Thank you so much. So have I been saying it wrong? Is it Hornsby Wilson or is Wilson okay? I'll say whatever you want.
Hornsby Wilson is preferred.
Hornsby Wilson. Mr. Hornsby Wilson, what do you want to share on behalf of Ms. Edwards?
As stated earlier, Ms. Edwards is 32 years old. This case has been going on for quite some time, being a 2020 case, and all of the other co-defendants have had their matters resolved.
Actually, a couple of them are in the wind. Mr. Prince had his matter resolved, but I think that we never ended up getting our I may be mistaken.
Well, it's my understanding those 2 were on diversion program.
Oh, that may be why it says judicial hold. And so they're working through a diversionary option.
Correct.
Got it. Okay. You are correct.
And so she's looking forward to getting this matter resolved. At the time, she was homeless. That's really why she was in the property. And it was unfortunately the wrong place, wrong time. And she does understand that she's looking forward to getting on probation, so getting this behind her. In terms of the condition that was spoken earlier, and ADA Jordan may be correct, she wants to be able to see her husband who is in jail, and I wasn't sure whether or not on probation she would be able to see someone who is a convicted felon. So we would just—
I don't impose that condition. I know some judges say you can't be around, I don't know how you define that, criminals. Are you a criminal because you had a conviction before? I'm not sure, but I'm happy to make explicit that Ms. Edwards can visit her husband, but I don't think she'd be prevented from doing that because she's on misdemeanor probation.
Okay, so if that's the case, then I don't think we need that as a condition.
Okay.
But yes, as I said again, Ms. Edwards is looking forward to putting this case behind her and moving forward.
Okay. Ms. Edwards, your husband is where?
He's in Telfair State Prison.
In where?
Telfair.
Telfair? Okay. How long is he there?
Until July of next year.
Okay. For what?
It was a manslaughter charge.
Okay. How long has he been there?
9 years.
How often do you get to see him?
Every weekend.
Every weekend? Okay, good. Anything you want to add?
No, sir.
Ms. Edwards, I need to make sure that you understand how an Alford plea works. You are saying, I didn't necessarily do what the state says. Maybe it wasn't your marijuana. It sounds like you were there, but being there, being merely present, isn't necessarily proof of the crime. But a jury might decide all the stuff was yours. Who knows? And then you could be on the hook for even more than what you're pleading to. And so I can accept an Alford plea where a defendant says, I don't agree with what the state says, but I think it's in my best interest, meaning Ms. Edwards' best interest, to go forward with the plea. Does that describe your situation?
Yes, sir.
You understand it still shows up as a misdemeanor on your record. It's not first offender. You've already had a misdemeanor, so you couldn't do first offender. So you now will have one more misdemeanor conviction. You understand that?
Yes, sir.
Okay. Well, I find there's a factual basis for your plea to the misdemeanor, and that your plea is knowing and voluntary. Ms. Edwards, do you authorize my staff to sign on your behalf the indictment indicating your offered plea to the misdemeanor?
Yes, sir.
And Mr. Hornsby Wilson, can we sign for you?
Yes, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
Okay. Ms. Edwards, I'm going to sentence you to 6 months probation. It sounds like you have not been in any type of trouble since this happened. That was a while ago, and that you're just trying to go about your business. So I'll make it 6 months. You will be subjected during those 6 months to random drug screens, meaning they'll call you, you got to come in and provide a specimen. But other than that, that'll be the extent of it. Do you have any questions about that?
No, sir.
Okay. You're going to need to stay here because Ms. Nelson is going to reach out to misdemeanor probation. And they're going to come down here and meet with you to give you the information you need about where to report and when.
Okay.
Okay. Anything else, Mr. Jordan?
No, Your Honor.
Anything else, Mr. Hornsby Wilson?
No, Your Honor.
Okay. Thanks for your help with this case.
May I be excused?
You may, as long as Ms. Edwards stays here, and we'll let you, you're not going to know, they don't wear a big hat that says probation, but the deputy knows who you are and he'll connect the two of you.
Okay.
And you'll have, once you've connected with misdemeanor probation, you'll be free to go.
Okay,
All
thanks.
right. Thank you, everyone.
Thank you.
All right. Ms. Wood, you got about 80 of these. What's next?
Judge, that's not true. I do have an announcement on position 26.
26. Mr. Owens.
Yes, Judge, this one is not going to resolve the day. We'd be ready for trial.
Okay. Mr. Whitenauer, ready on Mr. Owens?
We'll be ready, Judge.
Okay. Thank you. So do you need Mr. Owens to stick around?
Here you go.
Mr. Owens, you are, which one's Mr. Owens? That's what I thought, because someone in the back just raised a card, but, okay. You may want this guy to sub for you. Mr. Owens, you'll probably be on the short list for next week, which means you'll need to show up on Monday morning. Ms. Wood will confirm that with you. Does she have a good way to reach you? Okay, then you are free to go, and I may see you on Monday morning, okay?
Judge, on position 6, Vondi Humphrey,
Yes.
I did not make it all the way through the plea papers work with him, but I think we can get through it without it. His aunt is here, and so I wanted to make sure we got.
Why don't we do that then? I'm sure they'd love to start moving some of the folks back there too. All right. Humphrey, Deputy Gordon says from his seat. Get Humphrey.
And Your Honor, this will be a plea only to count 1, the willful obstruction felony variation.
Not to fair evasion. You're dropping all the big misdemeanors that you got out here.
If they ask any questions that you don't understand, just let me know and we'll step away and go over it, okay?
Yes, ma'am.
We ready, Ms. Wood?
Yes, Judge, I'm sorry.
That's okay.
Yeah.
Mr. Humphrey, good afternoon.
Good afternoon, sir.
How are you?
Good.
Good. I'm gonna need you to speak up a little more.
Great.
Great. You can be good or great. The better you are, the better I am. But I just need to make sure our court reporter, who is appearing virtually, can hear you. Mr. Humphrey, I'm been told you're ready to move forward with the plea. Is that correct?
Yes, sir.
We're going to do that today. Sounds like the state is going to dismiss the misdemeanor and you're going to go forward with the obstruction charge. In just a moment, Mr. Jordan, the prosecutor, is going to put you under oath. Once you're under oath, I need you to provide only truthful answers. Will you do that?
Yes, sir.
Okay. Will you let Ms. Wood know if you are confused by anything or need more information?
Yes, sir.
Great. Mr. Jordan.
Thank you, Your Honor. Mr. Humphrey, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Bonnie Darian Humphries.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
43 years of age, 10th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with willful obstruction of a law enforcement officer by use of threats or violence, being a felony variation?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Humphrey's name?
So waived.
Mr. Humphrey, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, are you aware of any outstanding warrants that are related to these charges?
I do not.
Mr. Humphrey, has your attorney advised you the maximum and minimum sentence for the charge that you're pleading to?
Yes, sir.
And Your Honor, for the sole count here, the minimum is 1 year in custody and the maximum is 5 years in custody. Mr. Humphrey, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state does move to dismiss count 2. In regards to count 1, the state's recommendation is 5 to serve 1 community time served. He has actually been in custody for 189 days. The balance being probated. And I apologize, Your Honor, there were some conditions that we spoke about. And Your Honor, in regards to this, in exchange for this plea, the state will either decline or not present to the grand jury 22 CP 211578.
And how does that happen? Will you file some paperwork, or you're just hoping that some other lawyer in your office files paperwork?
No, Your Honor, I've already talked about this with my deputy and we will have the paperwork filed.
Okay, so Mr. Humphrey, you've got some other set of charges out there. What do they involve? Do you know?
Your Honor, it's a very similar charge. I believe it's another felony obstruction.
Okay, you had another disagreement with a police officer and the state is going to dismiss those charges in connection with your plea today. Do you understand that, Mr. Humphrey?
Yes, sir.
Okay, thank you.
And Your Honor, the only special conditions of probation is that he be assigned a mental health probation officer. And I believe he's already been issued a lifetime ban from MARTA in regards to this situation, Your Honor, so that he just continue to stay away from MARTA.
And does that mean trains or trains and buses?
Your Honor, from my understanding is it may just have been 2 trains, but I'm not sure if they communicate well enough with each other to be able to say that if he were to get on a bus, that they would know that Mr. Humphrey is not welcome on that bus. This particular incident happened with the train.
Okay, well, I'll hear from Ms. Wood on that as well, because one is much more expansive than the other, to say no MARTA at all versus no trains.
Absolutely.
Okay.
Mr. Humphrey, do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering the guilty plea today?
Yes, sir.
Do Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit or any of the special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and the ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Humphrey, how do you plead to the sole charge of willful obstruction of law enforcement officer by use of threats or violence in indictment number 21 SC 178548?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Wood, have you advised to Mr. Humphrey his deadlines for filing an appeal?
Yes.
And Your Honor, for a factual basis, on February 25th of 2021, an officer from the MARTA Police Department observed a male acting suspiciously by entering the station through an emergency door on the eastbound platform. The officer then made contact with the defendant, Mr. Humphrey, on the westbound platform, and Mr. Humphrey immediately became disorderly. The officer instructed Mr. Humphrey to produce a breeze card so that it could be checked at the nearest breeze machine. Mr. Humphrey refused to comply and boarded train 103. The officer instructed Mr. Humphrey to exit the train, at which time he did not comply. The officer then attempted to place Mr. Humphrey into handcuffs. Mr. Humphrey snatched away and assumed a fighting stance. The officer attempted to gain control of Mr. Humphrey's wrist, and Mr. Humphrey began to violently snatch away and attempted to flee. He then did dive into an adjacent seat in an attempt to flee. The officer did advise Mr. Humphrey that he would be pepper sprayed. The officer then tried to gain control of Mr. Humphrey's left wrist, at which time the officer was struck by one of Mr. Humphrey's feet in his right leg. Your Honor, at that time, the officer then did attempt to tase Mr. Humphrey, and Mr. Humphrey did continue to resist. They were able to eventually successfully tase him and then arrest him for the offense of felony obstruction. Your Honor, that does conclude a factual basis for this for this case. I did speak with the officer who responded to this incident, and also the officer that responded to the incident in the unindicted matter. I believe both of them said to me that they just wanted Mr. Humphrey to get help. They believe that it was very much a mental illness situation to where Mr. Humphrey wasn't able to control himself. So we did believe that this is a fair negotiated resolution, Your Honor, and we would ask that you accept the state's recommendation.
Okay. Ms. Mann, how many cycles do you have for Mr. Humphrey?
Yeah, I have 26 cycles, and one of those are including the one that is here before on you. So that would be 25.
Okay. And I don't have a criminal history. If he was a repeat offender, it didn't pop up in the docket for this. What's Mr. Humphrey's most recent conviction?
Okay. Most recent conviction is, I think this is the one that he was here on before. There is a 8, 10, 20, no, that's the one he's here on before with you. 3, 18, 17 probation violation, Your Honor, for battery, criminal trespass, and time expired on that case, Your Honor. The one prior to that would be 4, 17, 2014. Probation violation, obstruction of an officer. That was another probation violation, and that was a probation revocation heard on that, Your Honor, on 6/12/2014. Would you like for me to continue?
No, ma'am, that's perfect. Thank you so much.
You're very welcome.
Ms. Wood.
Thank you, Judge. First, before I forget, I neglected to tell Mr. Jordan, Mr. Humphrey actually spent some additional time in custody on this. He had this case, and then he picked up the second one when he got rearrested. So he's actually done a total of 242 days, and I just sent Ms. Nelson those dates. He's 43 years old, Judge. He does have a 10th grade education. He lives in Decatur with his aunt, Miss Norma Kitchens, and I know that she's more than willing to tell the court anything that they might want to know about his background. He is diagnosed with several different mental health struggles, Judge, and has battled those issues for the past 10 to 15 years. Miss Kitchens tells me that everybody in her neighborhood knows him and knows that he's completely harmless and that he's unwell, and the issues usually happen when he wanders outside the neighborhood. So that is why we think it's important to have a mental health probation officer to maybe help him stay on track. He actually has an appointment on the 28th with the DeKalb County Community Health Board. Ms. Patterson had actually hoped to get him into Viewpoint to help him regulate his medication, but since he doesn't have an official diagnosis through the jail, that didn't work. So we are hopeful that with Ms. Kitchen's support and help on the outside, that he will be able to get in with the health board in DeKalb County and maintain his medications properly. And we just ask that you accept the state's recommendation.
So Mr. Humphrey didn't seem to think he was taking medication, which may be correct at this point. But it's important that he does so when he is out. Mr. Humphrey, do you remember in the past ever taking medicine to help you with things, or?
Yes, sir. I've taken like Haldol and Risperdal.
Okay. And if those get prescribed to you again and they're part of your probation in this case, will you take those medications?
Yes, sir.
Do you know where to go to get your medicine?
Yes, sir.
Where's that?
DeKalb.
Well, DeKalb's a pretty big county. You have an idea where in DeKalb to go?
The Community Health Service Board.
Okay.
Community Service Board.
And does your aunt help you get to places when you need to get somewhere?
Yes, sir.
Okay. All right.
Judge, one other thing I wanted to just talk about, the MARTA lifetime ban. I'm not super familiar with that. I do have some issue with that.
I can't do anything. I mean, the most I could do would be the term of probation, which couldn't be more than 5 years. So the most I could say is no MARTA for 5 years.
Just wanted to put on there that a MARTA suspension check was performed during the arrest and he was not suspended from MARTA at that time.
Okay. I am going to take some action on that, but it was helpful to hear the facts and to know where it is that Mr. Humphrey lives. Mr. Humphrey, do you have any questions?
No, sir.
Okay. Mr. Humphrey, I find that there's a factual basis for your plea, meaning if this went to trial and the police officers came in and testified, the jury could find you guilty. I also find that your plea is knowing and voluntary. And all I mean by that is that you've understood what we've talked about. Have you understood? And when you didn't, you've asked Ms. Wood questions about that?
Yes, sir.
Any questions right now?
No, sir.
Okay. And voluntary means no one's forcing you to do this, but you've decided after talking with Ms. Wood and maybe talking with your aunt that this is how you want to move forward. Is that true?
Yes, sir.
Okay. I'm sentencing you under the Probation Options Management Act. And what that means is that while you're on probation, if you have a small violation, maybe you miss a meeting, something real minor, you and probation will resolve that. But if it's a big violation, you get in a fight with the police again, something like that, that comes back to me and we'll figure out what we're going to do. Okay. Mr. Humphrey, do you authorize, is it okay for my staff to sign your indictment indicating that you've pled guilty to that one count and that the other count's been dismissed?
Yes, sir. Okay, sir. Yes, sir.
Okay. Ms. Wood?
Yes, Judge.
Mr. Jordan?
Yes, Your Honor.
Mr. Humphrey, I'm going to sentence you on the only count that's left, that's count 1, to 5 years to serve 8 months with the balance on probation. So you've already served 8 months, so you ought to get released anytime now. So it's 5 years to serve 8 months, balance on probation. I'm going to request that the Department of Community Supervision, that's probation, they provide you with a mental health probation officer, someone who will be more attuned to your needs and more supportive of them. It will be a special condition of your probation that you not ride MARTA trains, okay?
Yes,
You can ride MARTA buses, but no MARTA trains. If something needs to change because you got a job or a situation where the best way to get there is on a train, you should talk to Ms. Wood and then we can have a conversation about that. But for now, you can ride the MARTA buses, no MARTA trains.
Yes, sir.
Okay. It'll also be a special condition of your probation that you take any medication that any doctor prescribes you.
Yes, sir.
So if they say Haldol, it's Haldol. If they say something else, that's what you need to take. If it makes you feel odd, you go talk to the doctor and maybe the doctor will give you a different medication, but you don't stop taking it just because you want to. Okay.
Yes, sir.
All right. Mr. Jordan, anything else?
Nothing further from the state, Judge.
Ms. Wood?
No, Your Honor, does he need reporting instructions?
He does. Ms. Tucson, can you help Mr. Humphrey out with reporting instructions?
I sure can. Well,
I guess we'll need to get that address.
Miss Wood, will you be speaking with him afterwards, or because I could send everything to you, or where will Mr. Humphrey be residing?
I can get, if you'll send it to me, I'll make sure his aunt gets the information. I'll also write it down and the deputies can make sure he gets it.
Okay, and Mr. Humphrey, what county will you be in?
DeKalb.
Okay, so what I'm going to do, I'm going to get everything together since I do have you here in the system. You'll need to report on the date given on the reporting instructions. So that way you won't get a warrant for non-report. And since you're gonna live in DeKalb, you will report to DeKalb under a Fulton County case. So if anything happens, it will get sent back to Fulton, but you can be supervised in DeKalb County. Understand that?
Oh, yes, ma'am.
Okay. Thank you, Ms. Tucson.
Okay, thank you.
All right, Mr. Humphrey, good luck with things. And thank you, ma'am, for being here for your nephew.
Thank you, Judge.
You bet. Ms. Primovic, do you want to? She's not here.
She stepped out to speak with one of her clients about a plea.
Okay, I want to keep us going. So if she's, okay, you can drag her in here. And ma'am, you're with the public defender's office?
I am.
Okay. You want to take one of the pleas?
I haven't prepared one.
coming.
Okay.
Your Honor, I saw another gentleman come into the court very briefly. I'm not sure if it was Mr. Montgomery or not.
Well, why don't we sound for both of them one last time? Mr. Montgomery? And how about, who was the other one? Mr. Anthony?
He's talking to his mom out.
Oh, Mr. Anthony made it.
Yeah.
Okay.
We've been talking and
Call off the bench warrant.
we're hoping to take care of that today. He's talking to his mom.
Okay, are you ready on one? Ms. Wood went back into custody. She's just visiting.
I can go forward with Nicole Roberts.
All right, Ms. Roberts, come on up, please. That is position 24.
And Your Honor, this will be a misdemeanor plea as well.
Okay.
Count one will be reduced from aggravated battery to battery.
Yep.
And count two will be reduced from aggravated assault to simple assault.
Okay.
And count three will be dismissed.
Got it.
Go ahead.
Ms. Primovic, you ready?
I am, Your Honor. Thank you.
Great. All right, Ms. Roberts, you are position 24 on our calendar. It's 22 SC 183018. You ready to go forward?
Yes, sir.
All right. Mr. Jordan's going to put you under oath. You've now witnessed a bunch of these. It's your turn. Once you're under oath, truthful answers only. And please let Ms. Primovic or me know if you've got any questions. Will you do that?
Yes, sir.
Great. Mr. Jordan.
Yes, Your Honor. Ms. Roberts, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Nicole Roberts.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
32, college.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offenses, even though this is not what you're pleading to, of aggravated battery and aggravated assault?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Primovic, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Primovic, do you waive formal reading of the indictment?
So
Do you also waive any and all defects in the indictment, including any with respect to Ms. Roberts' name?
yes, sir, we do.
Ms. Roberts, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Primovic, do you know of any outstanding warrants?
We do not.
Ms. Roberts, has your attorney advised to you the minimum and maximum sentence for each charge that you were pleading to?
Yes, sir.
And Your Honor, since these are two misdemeanors, the minimum for both is 1 day and the maximum is 12 months.
And did you say the aggravated battery is being reduced to battery or simple battery? Battery. Okay.
Ms. Roberts, do you understand that this is a negotiated plea of guilty, which means that the state will recommend the following sentence? Your Honor, as previously stated, the state did offer a reduced count 1 to battery. The recommendation for that count being 12 months probation. The special conditions of probation being that she have no violent or harassing contact with the victim, and also that she have no brass knuckles while on probation, and that she complete an approved anger management course. As to count 2, which is being reduced to simple assault, the recommendation is 12 months probation to run consecutive to count 1, and the state is not opposed to termination of probation after 12 months if there's no violations, Your Honor. And as previously stated, the state does move to dismiss count 3.
All right.
Ms. Roberts, do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that since you were being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
That's for felonies, my apologies. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Ms. Roberts, how do you plead to the charges of battery and simple assault in indictment number 22 SC 183018?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that since these are misdemeanor charges, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty?
Yes.
And Ms. Primovic, have you advised to Ms. Roberts all of her deadlines for filing direct appeal?
Yes, sir.
And Your Honor, for a factual basis, on July 17th of 2020, an officer from the Atlanta Police Department responded to a call regarding disorderly children at 2328 Campbellton Road Southwest. Upon arrival, he met with the victim of the assault, Miss Marsha Hawkins, and that's MARSHA. Last name Hawkins has normal spelling. Miss Hawkins explained that there were 2 boys throwing rocks in the neighborhood and a rock hit her door. She approached the boys and told them to stop throwing rocks. A woman named Lanchia Cost, which is LANCIA, last name Cost, COST, came to Miss Hawkins' apartment and started a verbal altercation. At some point during the altercation, another female who lived in the apartment came up to Miss Hawkins and suddenly punched her in the face one time. The female had brass knuckles on. Miss Hawkins then suffered a laceration to her nose, and Miss Hawkins did later inform the state that she did suffer a broken nose as a result of the punch. And there also was a photo lineup that was conducted, and Miss Hawkins did advise or did pick out Miss Nicole Roberts as the individual that assaulted her. On September 17th of 2020, a warrant was then issued for Miss Roberts' arrest. Your Honor, that does conclude a factual basis. I've spoken with Miss Hawkins multiple times in regards to this case. She said that she has no issues with Miss Roberts. They may have even run into each other at a store that Miss Roberts may work at. And she said that Miss Roberts was very kind to her. She felt like the situation just got out of control regarding, I believe that Miss Cost or Miss Roberts may have been the parents of the children that were throwing the rocks. She does feel bad about calling 911 in regards to something so small. So she had no issues with a misdemeanor reduction here. She feels like it was a one-time incident, and she has no issues or no concerns about further violence, Your Honor, from Ms. Roberts.
Okay. That's generous of her. She got her nose busted, but
That's right.
I guess she's moving on.
She had no restitution request either, Your Honor. So she was fine with it, and I understood. So the state would just ask that you accept this negotiated plea, Your Honor.
Okay. Ms. Mann, what criminal history do you have for Ms. Roberts, if any?
Your Honor, I only have one cycle, and that is the case that is before you today. Therefore, she has no prior history, Your Honor.
All right, thank you. Ms. Pruvik.
Thank you. Your Honor, needless to say that there was no brass knuckles involved. So the condition on the brass knuckles, I don't think is going to be a difficult time. She did pop her in the nose. There was a situation that was going on with the children. She admits to that. She lost her cool. It had to do with her children. And
So either one or both of the boys are Ms. Roberts' kids?
yes.
Correct.
Okay.
So she has three sons and a daughter on the way. She's 32 years old. She's been working at Rose's for the past year.
Rosa's as in the pizza place?
No.
As
Oh.
in
It's a
the,
retail.
the little store. It's a kind of a
Yeah.
department store. There's only 3 left in the Metro Atlanta.
And it's Rose's?
Mhm.
Okay, what do they sell?
Clothes, shoes,
Oh,
electric.
so it's like a department store.
Mhm.
Yeah, kind of.
Where's the store you work at?
Campbellton Road.
Okay, so near, do you live on Campbellton Road?
Mhm.
Okay, so near home. All right.
Your Honor, so we're asking, we appreciate the state after 12 months, if there's no issues and she completes her anger management, for her probation to be suspended.
Okay.
We appreciate the state's offer.
I'm glad there are no brass knuckles, but I'm also disappointed. I've never had a case with brass knuckles. I was want to know, where'd you get them? What do they look like? Doesn't it hurt your hand when you use them? I would always think that it would just mess up your hand if you hit someone with, mess up someone's nose, but yeah.
Exactly what I said, Judge.
Where did you go to college?
Barter College,
For how long?
4 years.
And what degree did you get?
Criminal justice.
Why aren't you a defense attorney or a police officer or something?
No.
Okay, you're working at Rose's instead. All right. Ms. Roberts, is there anything you want to add to this?
No, sir.
Does Ms. Hawkins, so you and Ms. Hawkins live in the same apartment complex?
No, we don't.
No, okay. But she shops at your store? She seems to,
We
there was
live
a
in the
request.
same neighbor, somewhere around the same area.
Okay, so you might come across her from time to time?
Mhm.
Okay, all right. Well, Ms. Roberts, I find there's a factual basis to what this case has been reduced to. As Ms. Primovic put it, you popped Ms. Hawkins, and you shouldn't have. If she hit you first, then maybe it's self-defense, but if it's just people fussing at each other, it's not okay to escalate it. Whether you had brass knuckles or a sledgehammer or whatever, you shouldn't be hitting someone. Bad example for your kids in particular, but I guess you know that. So I find a factual basis. I also find that your plea is knowing and voluntary. No one's forcing you to enter this plea.
Mm-mm.
No?
No, sir.
Okay. And you understand everything that folks have been talking about?
Yes, sir.
Okay. Do you authorize Ms. Roberts, my staff, to sign the indictment indicating your guilty plea?
Yes, sir.
Ms. Primovic?
Yes, sir.
And Mr. Jordan?
Yes, sir.
Okay. Ms. Roberts, I will follow the negotiated resolution, and on count 1, sentence you to 12 months. Count 2, count 1's been reduced to battery. Count 2's been reduced to simple assault. Count 2 will be 12 months. They'll run consecutive to each other, so 24 months total. Special condition of probation number 1, no violent contact with Ms. Hawkins. Whether she calls the police on your kids or not, don't hit her. Again, brass knuckles or plastic knuckles, or just Robert's knuckles, no knuckles. You'll need to take an anger management course, and probation can help you find one. You can find one on your own, but it needs to be the kind of thing where you get proof that you completed it, not just I went to Joe's anger management course, but something where there's a certificate or something you get as a result.
Yes, sir.
And if you have stayed out of trouble, not busted Ms. Hawkins's nose again after 12 months and you've completed your class, then I'm happy terminating your probation early.
Okay.
Mr. Jordan, anything else?
Nothing further from the state, Your Honor.
Ms. Primovic,
No, Your Honor, thank you.
when is number 4 coming along?
May, end of May, maybe June.
You done after that, or are you trying to set a record?
I'm done.
Okay. I mean, you control some of this as to whether there's a baby in there, you know.
Yeah.
Okay. All right. Well, good luck with number 4.
Thank you.
I need you to stay here because misdemeanor probation is going to come down here and meet with you so you know how to sign up. Okay.
Okay.
All right.
Thank you.
Thank you.
Take care.
So I have a couple of announcements.
Let's do announcements.
Okay, here's my calendar. So Ms. Edwards, she's positions
She's 2 positions.
21 and 30.
Yeah.
That is not going to resolve today, and we would be ready for trial, Judge.
Okay. Mr. Jordan, I would probably make this ahead of any other Whitenauer case besides Grant, just so he's not back to back. You would be picking which case goes first. I'm hoping it would be 30, but you tell me.
Yes, Your Honor. It would be position 30 that we would ask to go first.
Okay. All right. So if we're going to try one of Miss Edwards's cases, it would be position 30.
Yes, Your Honor.
All right.
Got it. Thank you, Judge.
Okay.
And
Is
another.
Ms. Edwards still here? She is. Do you need her to stay anymore?
She's free to go. We have
Okay.
great contact.
Don't run yet, Ms. Edwards. So you know, you are likely going to be one of the people I need to see on Monday. So don't make plans for next week other than to be with me. Ms. Wood will be in touch with you, but I suspect that the email that I send out is going to have your, I don't know which is more recent, but the more recent indictment. These are all old situations from a bunch of years ago, but the trafficking case is the one that we would try. Okay? All right. So that is an announcement.
I have a second announcement on Mr. Bryce, position 17.
Mr. Price, yes.
So Judge, on this one, like I sort of hinted at, Ms. Patterson has gotten him into 2 different programs. So one of them would be helping him with the mental health aspect. The other one would just be helping with housing. Mental health is good to go. The housing is the problem. Mr. Jordan and I thought we might be able to have a family member that could step in, but it seems like that's not going to be able to be done today. So can we move this from the trial calendar just to a regular?
We can, and if we have more time today, what I'd say is, well, why don't we at least take the plea
Okay.
and hold off on sentencing? But I bet we're going to run out of time because I have to leave a little early today, but let's hold off.
Okay.
If we do have enough time, I'd love to get the plea in place and I can even pronounce the sentence saying, but this piece isn't in place. Otherwise, yes. Once Ms. Patterson knows that the housing component is in place, we'll put it on an inquiry calendar, a month or so out, but if it can happen sooner, we'll do that.
Okay.
All right.
Perfect. And finally, Judge, I believe we could go ahead and do Mr. Timothy Anderson whenever the court is ready for that one.
Well, it's your turn because we just did we just do a primitive plea? I think we did. I'm losing track. Yeah, it's the brass knuckles. Hey, Ms. Edwards, did the misdemeanor probation show up?
Not yet.
Not yet. Oh, we just called. Okay. All right. Well, now I have 2 people to see. Who do you want to do? You said Mr. Anderson?
Yes, Judge.
All right. Mr. Anderson. Number 29. All right. Who do we have in the second to last row? They're very actively waving things around.
What goes on?
I don't get to decide that. Yeah, I ultimately do, but let's see. That's Ms. Primovic. So when she comes back in, talk with Ms. She's right there.
Question?
Oh, Mr. Coleman was just waving body parts around and wanted to know what's happening.
He wants a trial, Your Honor, so
Okay,
did he come back Monday?
hold on one sec. Let's look.
So they haven't already done. So that's when you issue the credit. You've been in since this day, so you get all that credit. So it's just probation. And then you go through holding is automatic. Okay,
Thank
go with that. If you have any questions, since we didn't have a chance to talk about that, just say, Judge, I need a moment and you'll settle that.
Mr. Jordan, if,
It's mine, Judge.
oh, Coleman is yours?
Coleman, I thought that was, sorry, I was thinking of a different case.
No, we're doing Mr. Anderson for a plea, but we need to deal with Mr. Coleman briefly. Mr. Jordan, you've got position 9, your case?
Yes, Your Honor.
Mr. Coleman is not interested in whatever offer you've made. And so he wants to go to trial. If we bring him back on Monday, are you ready to go with that?
Your Honor, there is one slight issue with that particular case. I believe that the victim in that case is a child. The state has had an issue with getting the father in contact with the father of the child. I believe that we would be ready for that on the next trial calendar, but not this particular trial calendar, Your Honor.
Okay. I'll factor that in. That's not Mr. Coleman's problem, of course. So I may keep it on, and I'm now aware of your concern, but that may be something that your team would need to work through in the coming days.
Understood, Your Honor.
So count 1 is aggravated assault, and then there's a simple battery as well. And there's obstruction of an officer. The child is not the officer. Is the child the victim of the simple battery or the ag assault, or it's the same?
The aggravated assault.
Okay, got it. Thank you. And by child, is it like a 3-year-old or?
I believe the child at the time was 14, so he should be around 16 years old now.
Okay. I understand why you're working through the parents, and that's appropriate. I just, in terms of, we don't need to get any special assistance because it's a minor where we might need to clear the courtroom or anything.
Yes.
Okay. All right. I made that note. Thank you. All right, Mr. Anderson, I'm sorry to keep you standing right there. We were just working through Mr. Coleman's situation. So, Ms. Rivers, I haven't checked on you in a minute. Are you still good? Excellent. Well, let's press on. This is position 29, State versus Timothy Anderson, 22 SC 184011. Mr. Anderson, Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes, sir.
Okay. Mr. Whitenauer is the prosecutor in your case. He's going to put you under oath. Once you're under oath, please answer his questions and mine, and I'll have a few, truthfully and completely. And let Ms. Wood or me know if you've got questions. I need to be comfortable that you've followed what's going on. It's not meant to be complicated, but it's not a low stress environment necessarily. So if you hear something that's not fitting with what Ms. Wood told you, please let her or me know and we'll work through it. Okay?
Okay, yes, sir.
All right. Mr. Whitenauer.
Yes, Judge. Sir, if you would, please raise your right hand as best you're able. Do you swear or affirm the testimony you're about to give in the matter pending before this court be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please lower your right hand. Please state and spell your true correct name and speaking to the microphone because there is a court reporter out there in the ether taking down everything that we say.
Timothy Anderson, TIMOTHY, Anderson, ANDERSON.
And if you would please state your age and your date of birth.
44 years old, January 13, 1989.
Can you say you said 34 or 24?
34.
Okay.
Are you now under the influence of any medicine, drugs, or alcohol?
No, sir.
How far did you go in school?
To the 9th grade.
Can you read and write in the English language?
Yes, sir.
And have you had an opportunity to review the document, that's the indictment, that charges you in this case?
Yes, sir.
Do you fully understand the nature of the charges pending against you?
Yes, sir.
By pleading guilty today, you're giving up rights. I'm gonna read those rights to you, and after each one, if you'll just indicate that you understand that you're giving up that right. By pleading guilty today, you're giving up the right to a trial by jury. Do you understand?
Yes, sir.
The right to be presumed innocent,
Do you understand?
Yes, sir.
The right to confront any witnesses who may testify against you.
Yes, sir.
The right to subpoena any witnesses for your defense.
Yes, sir.
The right to testify yourself and to offer any other evidence in your defense.
Yes, sir.
The right to have an attorney to assist you throughout the trial proceedings.
Yes, sir.
And the right to not incriminate yourself.
Yes, sir.
Do you understand that you're giving up all of those rights today by entering this plea of guilty?
Yes, sir.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury? Do you understand?
Yes, sir.
All right. And are you now serving any other sentence of confinement, or are you on probation or parole for anything anywhere?
Yes, sir. I'm on federal probation.
Okay. And do you understand that by pleading guilty today that your probation or parole could be revoked?
Yes, sir.
Okay. And sir, you understand that you're entering this guilty plea as a negotiated plea. The state will recommend that you be sentenced to 5 years to serve 6 months, the balance on probation, with special conditions of entering and completing, that you have no contact with the victim, that you stay away from the victim's residence and place of employment, that you complete the family violence intervention program, that you obtain your GED, that you possess no firearms, and that you abstain from drugs and alcohol and be subject to random screens. Your Honor, I would note that initially we had talked about drug court for this defendant, as the victim had indicated that drugs were an issue. But in speaking with defense, I understand that there is a hold from the Marshal Service in relation to that federal case. And so that might make drug court a bit tricky.
Okay.
Do you understand that the court is not required to follow the recommendation, but can sentence you up to the maximum sentence permitted by law, which in this case for the count 1 aggravated assault, that carries a sentencing range of 3 to 20 years in confinement. Do you understand?
Yes, sir.
All right. And do you understand that this being on the trial calendar, that you do not have a right to withdraw that plea once entered?
Yes, sir.
All right. Should the court sentence include a period of probation, you'll be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. I also mentioned just a moment ago, special conditions of probation. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, sir.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, sir.
All right.
It's in my best interest.
Okay, so you want to enter this plea under Alfred, is that correct?
Yes, sir.
All right, we'll get to that. Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with what your attorney has done for you in this case?
Yes, sir.
Do you have any more questions for your attorney before we go on?
No, sir.
Have you understood everything I have asked you so far?
Yes, sir.
In understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, sir.
How do you plead?
Guilty in my best interest.
Okay. And is your decision to plead guilty made freely and voluntarily?
Yes.
Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe that it's in your best interest to plead guilty today?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Sir, if you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition, and for the felonies, you have 4 years from today, and for the misdemeanors, 12 months from today to file a habeas corpus petition. Do you understand?
Yes, sir.
All right. Do you understand that you are not allowed to possess a firearm during the course of your probation?
Yes, sir.
Do you understand that if you were found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, sir.
All right. Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about February 27th of 2022, officers with the Atlanta Police Department responded to 12 Atlanta Avenue Southeast, which is located in Fulton County, and spoke with the victim in this case, Joy Butler, Joy Butler, Butler. Ms. Butler and Mr. Anderson, the defendant, had known each other for about 12 years and had been in an intimate relationship on and off during that period. They had last lived together from July to November of 2021. On the date in question, the two were in a period of breaking up and they were arguing over text. They met at that location, 12 Atlanta Southeast. Ms. Butler stated to Mr. Anderson, you must miss prison because you like being up here with all these men. That upset Mr. Anderson and he began to run after Ms. Butler, was able to catch her, punched her in the face and pulled a gun on her. At that time, Ms. Butler began walking to her car to leave and Mr. Anderson followed her into that vehicle. While in the vehicle, Mr. Anderson took Ms. Butler's phone and threw it out the window, and he also took the keys to the vehicle. The two continued to argue, and during that argument, Mr. Anderson pulled the gun from his waistband and held it to Ms. Butler's face again, threatening to kill her, stating things like, "I will end you right here." Anderson got out of the vehicle and announced to the parking lot that he was going to shoot Ms. Butler. That's when an onlooker in the parking lot said, "Don't do that." Butler was not sure who said that. She just remembers hearing that comment. In any event, she tried to get out of the car and walk away. As she was doing so, Mr. Anderson threw her phone out of the car. She picked it up, continued to walk away, and called the police. Your Honor, this defendant does have a criminal history. He has a conviction in 2007 for VGCSA here in Fulton, 2011, again, a VGCSA, and then in 2011, same year, possession of a firearm by a convicted felon. Those are all in Fulton County. Your Honor, one additional point is that before this incident, there was another incident with the same victim in a vehicle. Georgia State Patrol reported to that. Had this proceeded to trial, we would have attempted to share that with the jury as a prior difficulty.
So that didn't result in an indictment, or it was a state court case, whatever it is, that's not anything you've got.
I'm unaware of CP case. Judge, I have spoken with the victim in this case, and she has indicated that she is doing well, that she doesn't want the defendant, that she wants the defendant to get jail time, but said, quote, "Don't throw him away." It seemed like she still wanted him to get some help for what she thought were some drug issues. While I understand that drug court may not be ordered by this court, I would encourage Mr. Anderson to avail himself to that evaluation and maybe making some changes. In any event, Judge, we do ask that you accept the negotiated plea.
Got it. Ms. Tucson, is Mr. Anderson on active state probation?
No, Judge, not on active probation.
Okay. Ms. Mann, how many cycles do you have for Mr. Anderson, and do you have anything more recent in terms of convictions than those 2011 convictions that Mr. Whitenauer told us about?
Your Honor, there are 11 prior cycles, not including the one he's before you on today, and I don't have anything later than what has been presented to you, Your Honor.
Okay. Thank you so much.
You're welcome.
Ms. Wood.
Thank you, Judge. Mr. Anderson does squabble a bit with the state's version of events. However, after our office spoke with Ms. Butler and I shared what her perspective to our investigator was, Mr. Anderson did concede that it would be in his best interest to resolve this here instead of in front of 12 jurors. So that is why we're here today, Judge. He's 34 years old. He's from North Carolina. He grew up here. He has family here. I just found out he does have his GED, so it seems that condition will be satisfied rather quickly. He's got 2 children, 2 sons, 12 and 14. He has worked gainfully at the steel factory, the bread factory, at Iconic Catering Services. He has an HVAC certificate, some other certificates that he has mastered in the past couple of years. So once he's done with his time with the feds, he is eager to get back into society, Judge. We would just ask that you accept the state's recommendation, and he has been in exactly 265 days. So we would ask for all of that credit as well.
Got it. So, Mr. Anderson, where did you get your GED?
I got it while I was in Pennsylvania.
What were you doing in Pennsylvania?
Locked up in federal.
Oh, that was your federal sentence?
Yes, sir.
Well, that leads naturally into my next question. What is the charge, or what are the charges for which you were on supervised release?
Trafficking marijuana and possession of a firearm.
Okay. And was that a case here and you just happened to be at BOP in Pennsylvania, or was the case out of Pennsylvania?
The case was here.
Here, Northern District of Georgia?
Yes, sir.
Okay. How much time is left if they're going to revoke some of it because of this? How much time is left on your sentence?
They gave me 3 years supervised release. So I've been out probably just like over a year. Mr. McBurney, I got out, I obtained my license, my ID, I got jobs. I got out and I know Joy before, prior to me going to jail. And I thought it was in my best interest by her being an older woman. She could probably help me out. But, just trying to be a normal person. And it just didn't go right. I don't beat on her. I don't put my hands on her. I don't do none of that. I walk away as either fight or flight, and I'm leaving every time, Mr. McBurney. I worked at that store right there at that store. I worked there. They gave me a job. I just got.
What's the store there?
Atlanta Avenue.
No, but what's the store?
Oh, that's the name of the store, Atlanta Avenue.
What does it do? If I walk in,
no, it's just like a mom and pop store.
Okay, I could buy a Coca-Cola.
You can buy a Coca-Cola, a lottery ticket.
Okay, got it. Well, that's why it's an offered plea.
Okay.
Ms. Wood, as much as you're willing to disclose, it was helpful to hear how you reacted after Ms. Butler spoke to your team. Sometimes a victim in a scenario like this talks to the defense and said, everything I told the police, I was just mad at the time, I made it all up. Sometimes they say, it may not have been that bad, but here's what I'm going to say when I testify, which wouldn't necessarily be good for your client. Does it fall into that category or somewhere in between? Or I'm just trying to understand the import of your observation, because the way I took it was, once we heard from Ms. Butler, we let Mr. Anderson know, I want to work this out. She's not going to come in saying what you hope she's going to say.
Judge, on the body camera, she's very calm, collected, has it all together. She's
Yeah.
not frantic, crying or screaming and any of that. However, the quote that Mr. Whitenauer used about throwing away the same, it sounds like she told Mr. Whitenauer's office the exact same thing that she told our office.
Okay.
Which is, as you noted, sometimes not what happens in these cases.
Okay.
So yes, that's why my advice was this might be the best route.
Understood. Okay. Mr. Anderson, I want to make sure you understand how an offered plea works. That's when a defendant says, Judge, I don't agree with what the state says. I don't think that's exactly what happened. But I don't want to run the risk of going to trial. I think this opportunity that my lawyer has gotten me, which is effectively time served, is a better situation than the risk of going to trial. And so even though I'm not saying I did what the state says, I'm going to say guilty under offered. Does that describe your situation?
Yes, it does.
Okay. I can accept an offered plea, and I will in this case, because it certainly moves you forward towards then dealing with the federal situation. I need to make sure you understand it still shows up on your record. It's not like this is a NOLO, which also shows up on your record. It's certainly not a first offender, which you could get removed from your record. It's going to be a conviction. You understand that?
I understand that.
Okay. All right. Then I'm going to accept your plea. I find that there's a factual basis, which doesn't mean I'm buying everything Ms. Butler said. But if Ms. Butler came into court and said things that are consistent with what's on the body cam, a jury could believe her. You'd be running into sort of a, do they believe me or do they believe her? And you've described her as this nice older lady. Maybe they'd say, oh, that poor lady, look what this mean guy did. And you may not want to run that risk. So I do find that there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means even though you are not real enthusiastic about where you are right now, no one's forcing you to go forward. But you've decided after talking with Ms. Wood that is the right way to move forward for you. Is that right?
Yes, sir.
Okay. And a knowing plea is simply you've understood everything we've talked about. And you strike me as plenty smart. But has anyone said something that confuses you in any way? You may not agree with everything you've heard. That's not my question. It's whether have you understood everything you've heard?
I understand.
Okay. Got it. Mr. Anderson, I'm sentencing you under the Probation Options Management Act, which means when you're on probation, in this case, if you have a minor violation, you and probation work through that. You have a meeting with them and they may say, you got to do some community service or something like that. If it's a big violation, you get arrested again, or Ms. Butler has proof that you were texting her or showing up at her doorstep, those kinds of things, that comes back to me and I'll work through any consequences of that. Mr. Anderson, do you authorize my staff to sign the indictment indicating your offered plea?
Yes, sir.
Ms. Wood?
Yes, Judge.
Mr. Whitenauer? Yes. All right. Then let me work through the sentence. I'm going to look at the indictment. It's going to be easier to do it that way.
Mr. McBurney,
Yes, sir.
by me taking this plea, right, and by me being on supervised release from federal, how would that affect me? Because I like these allegations right here, I'm just trying to move forward with my life. I got my kids waiting on me. I just did 11 years. I'm trying to get to my life. I'm in jail and they killing people over here. It's tough over there. So it's like
I've heard. I have met a guy.
So I'm ready to go, but it's like I don't want to. If this gonna hinder me or cause me to be out my kids' life some more, I just want it to be fair. I didn't.
Okay.
beat this lady
No, I'm
up.
hearing you, and you've articulated real well your view on the Butler-Anderson relationship. So none of us here can say, here's the exact consequence with your supervised release. But until you resolve this case, you're stuck because you've got that federal hold. And we're not letting you go to the feds until we either have a trial. I think you know what might happen at trial. We just talked about that. Or you take a plea. Now, if you go to trial and you're found guilty, you might get a more severe sentence because I'll have met Ms. Butler and heard what she had to say, and I might start to think about things a little bit differently, but you'd certainly have a conviction, and it wouldn't be an offered plea. It would be a guilty verdict. And the feds are going to look at that differently than they're going to look at an offered plea. So I am not promising you that they're going to greet you with open arms, but you've got 3 ways to get to them. You go to trial and you're found not guilty, you go to trial and you're found guilty, or you take a plea. Otherwise, you're stuck here. And like I said, we're not going to do anything. We're not going to let you go to the feds until you resolve your case. Does that make sense?
It makes sense.
I mean, you're in a tough box. I get that. I'm not trying to make it sound like a good spot, but this plea moves you to that next stage because you want to get out and get back to your kids, and you're not going anywhere until you get back in front of Judge X. Who was your judge? Do you remember?
Johnson. Judge Johnson.
Judge Johnson. So you can get back in front of Judge Johnson and you'll have a federal defender with you. That federal defender will talk to this public defender to get the full scoop. Like, wait a minute. Oh my gosh, ag assault. And this thing. No. Let me tell you what this was really about. And you'll be there. It's not like this happens in a dark room and you're not there. All right. Did that answer your question?
It did.
Okay. So what I'm going to do in this case, you said 265 days?
Yes, Judge.
Okay. I'm going to sentence you. I want to make sure all of.
Battery is a misdemeanor. All the rest are felonies.
Okay. But isn't 3 a plus 5?
It would have to be consecutive, but Your Honor could suspend.
Okay. All right. Everything else can be concurrent.
Yes, Judge, I believe so.
All right. What I'm going to do, Mr. Anderson, is sentence you to 7 months to serve on counts 1, 2, 4, and 5. Those will all run concurrently. You'll get credit for the time you served, which happens to be more than 7 months. Count 3 has to be consecutive and it has to be 5 years. I'll probate that. So your sentence is actually going to be 5 years and 7 months. The 7 months you serve, I've already done that. You've got 5 years probation. Special condition of probation number 1, no contact with Ms. Butler. Don't write her, don't text her. If you guys are in the Twitter sphere together, nothing that, even if it's like, hey, I miss you, or I'm sorry we had this misunderstanding. If she shares something with the DA's office that shows you were reaching out to her, that's going to be a bad development. That's not meant to be a trap. If for whatever reason she's trying to get up in your business because she thinks she can get money from you, whatever the deal is, Don't write back. You need to let Ms. Wood know, look, she's calling me, she's texting me. Ms. Wood can work with Mr. Whitenauer, and then you're insulating yourself so that if she shows, look, all these texts to Mr. Anderson, but look, Mr. Anderson never wrote back. Now, I hope she leaves you alone. I know you will leave her alone.
I'm Miss McBurney. I'm just like so confused, man. Like,
Well, but I don't want you to be confused about no contact.
no,
Do
I'm
you have
not
any
confused
kids
about
with
that.
Ms. Butler?
No, sir.
All right. Do you have any shared friends with Ms. Butler?
No, sir.
All right. Leave Ms. Butler alone. Nothing confusing about that.
Okay.
Special condition number 2, you need to complete a family violence intervention program. That's a class, and you can't do it till you get out, so don't worry about it till you get out. It sounds like you already got your GED when you were in Pennsylvania, so I won't add that. And then what I'm going to require when you get out is that you have a drug and alcohol abuse evaluation. That'll be an expert. It's not me. It's not a lawyer. It's someone who knows about that stuff who's going to talk to you about your past. And if that person recommends any treatment, go to classes, NA meeting, something like that, that treatment will become part of your probation. That's it. All right. Mr. Whitenauer, did I leave anything off?
No, Judge.
Ms. Wood?
No, Your Honor.
So what's going to happen next, Mr. Anderson? I'm going to sign your final disposition, your sentence, today or tomorrow. And then the marshals will be notified by the sheriff, hey, we're done with this guy. And they're going to need to come pick you up so that you can get right down the street, get in front of Judge Johnson for whatever they're going to do with your supervised release. I hope that's the only business you've got anywhere else. That's the only hold we're aware of, okay?
That's it.
All right.
Thank you, Mr. McBurney.
Bet.
This is yours.
Thank you, Ms. Wood.
Everything done, you're welcome. There's my number if you have any questions or issues.
Judge,
okay?
might we
All right.
address, I know you mentioned you might have to leave
Thank you. Yeah,
early, but I wondered if we might
All right,
address
thank you.
position 28, Cyril Anthony.
In a minute, let me sign. I have a misdemeanor I need to sign for our brass knuckles.
Oh. Did I just? Where is that? This that promise.
I did, and I told him about it. And you know, in this day and age, there'd be some alloy that they've got.
Titanium.
Yeah. But the heavier, I assume, would be to
Yes.
pack more of a wallet.
Titanium.
We're so done.
All right, you've got Roberts. Boy, things are flying. Okay, yes, you wanted to talk about position 28, Mr. Ant, is that Mr. Anthony?
Yes, it is.
All right, so he's here, with no ankle monitor. Oh, it's just not, you're not paying for it, it's not charged, or what's the deal?
I tried to contact Ms. Billy further instructions to get it removed. Just haven't been in contact.
Okay, yeah, so she will help you get in touch with, I think it's called like A&A monitoring. And they'll either come to you or tell you where to go, and they'll put some magic thing in, but you don't want to mess with it because it's $600. And I've been learning today through drug court, it's a felony offense to tamper with it. So leave it alone. Mr. Whitenauer, your announcement on position 28, Mr. Anthony.
Yes, Judge. I've been speaking with defense about this case, and she has shared with me some important information about the defendant, about how he's in college and about all that he's doing there, and noting that this case is his first arrest, and asked for misdemeanor resolutions. And I thought that was appropriate, and made that offer with some certain conditions that would see him on track for graduating college and putting this case behind him. But it's my understanding that that's not the direction he wanted to go. So I thought maybe Your Honor might want to just address this case and Mr. Anthony.
Sure.
He's really thinking about it, Judge.
Mr. Anthony, why don't you come up, just be next to Ms. Primovic.
He would like some more time to talk about it with his mom. He spent a few hours a couple weeks ago with Ms. Feely in the office going over everything. This is such a big decision, and if he takes the misdemeanor with the probation, will it take first offender? And I said, you know, you have one in your life, and Do you want to do it on a misdemeanor? So he and his mom are having a lot of conversations about that. And he asked if he could have more time to make this decision.
Okay. Mr. Anthony, where are you in school?
I'm at Morehouse College, sir.
What year?
It's my senior year.
Senior year?
Yes, sir.
What are you majoring in?
Political science.
What's the plan after you graduate?
I would like to be a lobbyist.
A lobbyist?
Yes, sir.
Maybe we should send him to jail. Good for you. That's exciting. Is there a career track for that? How do you just become a lobby, other than getting a political science degree at Morehouse, which is going to connect you with lots of folks? How do you become a lobbyist?
Staying in contact with different firms and making sure that my interests align with those firms. And yes.
So people lobby for something or against? Is there a particular issue that you would want, or you just like, hey, you bring me your issue. If it's cigarettes, it's cigarettes. If it's I'm a lobbyist. I can chameleon into whatever you need me to.
I'm also interested in education. And if you look at my resume, it has everything to do with education, which is why I want more time to make this decision, because if I do accept those misdemeanors, that definitely will serve as a detriment for my career and the trajectory that I'm trying to go on.
Sure, unless you take first offender, in which case that'll all get expunged in the end anyway. And it's not a conviction, it's a temporary thing. But as Ms. Primovic said, you only get one first offender.
And I've never need another one.
Well, then there's a good time to use it if it's the one time you've been arrested. These are serious, serious charges. And I will tell you, your life will be very, very different if you go to trial and you're found guilty. That is worlds apart from how would a first offender misdemeanor affect me? If you were, and I'm not saying you would be, I don't know anything about the facts of your case. If you were found guilty of kidnapping, I would be required to send you to prison. It's got a mandatory minimum. I mean, it's not a good situation. But I'm sure your lawyers talked to you about that. And I want to make sure you've had a chance to think about it. Your case isn't brand new. In fact, you were arrested way back in 2020. And here we are coming up on 3 years. So what does more time mean?
I would just like, if it, is acceptable, just to be able to make a decision next week, just to fully go over all of the facts and just to weigh my options. And that's all I'm asking.
And who is it that you're conferring with? Your mom? Are there other folks who are influential with you and helping you think through this?
Yes.
Just what's an example? Friends or pastor or family members?
Professors,
Okay.
doctors.
Okay. Mr. Whitenauer, what's your thought? I guess you've got cases aplenty to move forward on. If we move Mr. Anthony to, what we would do for sure is put him on the next trial calendar, but what I'd probably do is get it on a calendar sooner than that, inquiry calendar. I don't control what you do, but I hope you wouldn't leave this opportunity open indefinitely because it complicates your planning as well. If there's a misdemeanor on the eve of trial, you've got to get ready for a very serious felony trial instead.
Yes, Judge. I would suggest to the court that if your honor is inclined to maybe put it a week or 2 weeks out onto an inquiry calendar so that you can have those conversations. But just with the understanding that come that calendar, that misdemeanor offer is no longer available. And as the judge indicated, that kidnapping charge, if you were found guilty, carries a minimum 10 years in prison.
So, Mr. Anthony, I think your request makes sense, and we'll do that. I just need to make sure you understand that when I see you next for that inquiry calendar, 1, you need to be on time. 2, it's in person, it's not Zoom. And 3, if you show up and say, I'm not interested in the offer, which is 100% you're right, Mr. Whitenauer has made clear that that offer expires. And so then the next time I'd see you, it would be for trial. And you may still be able to work out a deal, but what you would not be able to do is say, I'm here for that misdemeanor that Mr. Whitenauer offered, because he may say, not anymore, because it expired on that date. You understand all those things? Okay. I cannot give you a specific date right now because my master of scheduling is going to need to look at what would happen, but it would be soon. It won't be next week. I'll be in trial, but it would be soon, ideally in March, that I'll get you back in here and you'll let me know, you know what? None of these are easy decisions, but I picked the misdemeanor option with first offender or whatever you and it'll be Miss Feely again. She'll be back. You and Miss Feely work out. Okay. Any questions about any of that?
I just have One last request, if I can get a document saying that I was here at court today. Unfortunately, I missed the quiz for my microeconomics class, and I was blessed to have it out, leaving court. No, I didn't even know I had court today.
So we need to fix the more important is not your quiz, but you not getting noticed, because that's another way to get locked up. Let me look up your address to see meaning what's in the system. So got you at 800 West Marietta Street. Is there an apartment?
702B.
Okay, that's the problem, is it's just going to 800 West Marietta Street, no apartment. I need there's a change of address form. One of those 5 forms over there is change of address. If you could fill that out before you go, Ms. Primovic's going to get you one, but fill out the full address. Please put the apartment number in there. We'll get it updated in the system. Ms. Feely will certainly let you know when that court date is. Do we have some easy letter? A notice is coming out in just a moment about your situation.
Thank you, Ms.
Okay, that is position 28. Ms. Wood?
Yes, sir.
So let's confer as a group. I can do maybe 2 more pleas. For sure, I can do 1, maybe 2. I don't know how many we have left. We've got a gentleman sitting way in the back. We only have 1 back there. Okay, tell me how you guys want to do it.
I'm happy to go ahead and do the plea. Did you say sentencing, we could wait until the placement was in?
Sure.
Okay.
Yeah. Is that the only person who's still back there? Okay, and who's in court?
Your Honor, that is Mr. Danny Jones.
Okay.
And he is turning down his misdemeanor offer. And he would also like a trial.
Okay. Mr. Jones, can you come up a little closer? I need to make sure I can see and hear you, and vice versa. All right, Mr. Jones, my understanding is that Mr. Jordan has offered you a misdemeanor way of resolving your charges. It looks like you've got 3 felony and 2 misdemeanors. I may be slightly off, but you've got more than 1 felony charge in your case. You're not interested in a misdemeanor, is that correct?
There you go.
Okay, but I'm not saying you did anything at all. You are presumed innocent, and that presumption stays with you until either you say you're guilty right there, or a jury hears all the evidence and they say guilty. So I didn't say you did anything at all. I want to make sure you understand Mr. Jordan has offered a misdemeanor, I'm assuming with no jail time, other than what Mr. Jones may have already done.
Correct.
So it's misdemeanor probation.
Yes, sir.
Okay, that's what the offer is, and you're not interested in that. You want to go to trial. Tell me why you need time to think about it, because I know you're not a senior at Morehouse hoping to become a lobbyist.
It's hard when they got you mistaken.
Okay. I put the wrong thing down. You're number 7. Well, what I can tell you, Mr. Jones, is that I will give you time between now and Monday, but your case is probably going to be on that short list of cases for Monday. But that's not a penalty. The state has to prove you did something. And if you didn't, that's not your problem. They got to come up with the evidence, whether it's surveillance footage or a photo lineup or who knows what. I don't know any of that. Your lawyer knows and has negotiated this possible outcome for you. But I'm not pressuring you at all to accept it. I just need to make sure you understand what the offer is. Mr. Jordan the offer to misdemeanor probation is open until when? Until Mr. Jones walks out of the courtroom today, until Monday morning, what?
That's correct, Your Honor. The offer would expire today.
Okay, so Mr. Jones, you've got another 20 minutes to think about it here, if you choose to stay. I'm not asking you to stay, but I do need to make sure you understand that when you leave, then the state's withdrawing that offer. They may renew it. They may have their own issues with the case that you don't know about. They can't find a witness or who knows. Or it may just be a case where they think they're all right with misdemeanor probation.
I know I don't been in court at least 5 or 6 times.
Well, I don't want you to have to come back to court anymore. So that's why we'll do a trial.
Some people don't got thrown out or something. Ain't nobody showed up at court. None of that.
Well, that hasn't been no one has needed to come to court before other than you, because it's your case. So what I'm gonna do is probably have you come back on Monday. Ms. Primovic, does Ms. Feely have a good number for Mr. Jones?
Yeah, and I got a good number today.
Good.
I made sure.
Okay,
And I'm just gonna meet him out in the hall again.
good. So we'll just make double sure they know how to reach you, because you're not gonna get anything more in the mail saying come on Monday. I'm telling you now that you're gonna need to be here on Monday. If that changes, Ms. Feely or Ms. Primovic will call you saying, shh, nope, you don't need to come back here. But if you're here on Monday, it's for trial. It's not for some misdemeanor plea, okay? Any questions for me? No? All right, thank you. Appreciate your patience. Did Ms. Wood go back to talk to Price? All right, is there anyone we thought we were gonna deal with that we didn't?
Number 19, Judge.
18 and 19.
Oh, yeah, Mr. Jackson. Okay, and he's back there still?
It's a fail.
Okay, it's a fail. And so what will go would be, Mr. Whitenauer, you're in, as between the two of you. Okay. So 19. He's in custody.
Yes.
All right. And Mr. Price, can we bring him out now, or do you need another minute?
I think we can get through it, Judge.
Great. Jones, not a plea. So Montgomery is a bench warrant?
What number was that, Judge?
8. 9 is a trial. Hill's lawyer never showed up.
Just let me know and we'll step back and talk about it.
So this is Mr. Price. All right. Hey, Mr. Price.
How you doing?
I'm okay. Ms. Wood, are we ready?
Yes, Judge.
Mr. Price, I'm Judge McBurney. And Ms. Wood tells me that you're ready to enter a plea in your case. Is that right?
Yes.
Okay. The way this is going to work is that Mr. Jordan, who's the prosecutor, he's going to put you under oath in a minute, which means you're going to raise your hand. You don't have to do it quite yet, but he's going to have you raise your hand to swear to tell the truth. Then he's going to ask you some questions, and I may ask you some questions. Will you answer the questions for us?
Yes.
Okay. If you have any questions, will you let Ms. Wood know?
Yes.
If someone says something that doesn't make sense, will you tell me, wait, I don't understand that?
Yes.
Okay, great. Thank you, Mr. Price. When you're ready.
Yes, Your Honor, and the state is only proceeding forward on count 2, which is felony terrorist threats. The state is dismissing count 1, aggravated assault and violence.
All right, so Mr. Price, the state's dismissing half of your case. And we're just going forward on the part that says you threatened someone. You understand that?
Yes.
Great.
Mr. Price, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Fernando Kennard Price.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Prescribed medicine that doctor been giving me at
And you said the prescribed medicine that the doctor has been giving you?
Yeah.
Do you know what prescribed medication that is?
I think Respidol, double coat, that was it.
Can you speak into the mic?
Respidol, double coat, I think yeah, that's it.
And what are those medications for?
Hearing and seeing things.
I'm sorry, you're
Hearing and seeing things.
hearing and seeing things. Do those, to your knowledge, do those medications help you understand the proceedings today?
Let me ask in a different way. So when you take the medication, does that make you hear and see fewer things? It makes you feel better?
Yeah, it made me feel better.
Okay. Did you take the medicine? Do you take the medicine in the morning or at night?
I take it at night now.
Did you get it last night?
Yeah.
Okay. And when you take that medicine, does it help you sleep also?
Yeah, a little, sometimes.
Okay. Right now, are you hearing or seeing things other than what's going on here in court?
No.
Okay. If you start to hear something else or see something else, will you tell me?
Yes.
Okay. Thank you.
How old are you and how far have you gone to school?
Or like 11th grade, 24 years old.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offense of terroristic threats?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Price's name?
So waived.
Mr. Price, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Wood, do you know of any outstanding warrants?
We do not.
Mr. Price, has your attorney advised you the minimum and maximum sentence for the charge that you are pleading to today?
Understand?
Yes.
Okay, so say yes.
Yes.
And Your Honor, this is for terroristic threats. It is a minimum of 1 year and a maximum of 5 years.
Okay.
Mr. Price, do you understand that this is a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? And Your Honor, as we previously discussed, I do understand that the court is going to withhold sentencing due to the housing issue. The state's recommendation was to dismiss count 1, aggravated assault, family violence. As to terroristic threats, the state's recommendation was 5 to serve 1, commuted to time served. The special conditions of probation, being that Mr. Price have no violent or harassing contact with his mother, Miss Sharika Price. And I have to check the spelling, Your Honor. I may have.
The indictment has it as Shereka.
That's what I have as well, Your Honor. And Price has normal spelling. That he also be assigned a mental health probation officer. And Ms. Wood will talk about the particular programs that Mr. Price is currently trying to enter. So I'll withhold and wait for her report on that. And also that he stay current with his medication, because we, as you will hear from the plea litany, this just sounds like a situation to where Mr. Price wasn't on his medication on that particular day, and it led to the incident. Mr. Price, do you understand that the court does not have to accept that recommendation?
Yes.
Do you understand that the court can sentence you to the maximum on this charge?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Are you currently on probation or parole?
No.
You understand that since you're being placed on probation today, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction just as there would be from a conviction following a trial?
Yes.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and finally, the ability to obtain employment?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
You understand?
Yeah.
Okay.
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
You understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the sole charge of terroristic threats in indictment number 22 SC 182579?
We trying to say loud. Yeah. Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
You want to get up?
No, it's just talking about filing an appeal. It doesn't have anything to do with the sentence or getting out. It's just filing your, if you do a trial.
Oh, saying thank you.
So do you understand you have those deadlines?
Yeah.
Okay, so then say
Yes.
Do you understand that you have only 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
No, yes.
And Ms. Wood, did you advise to Mr. Price his deadlines for filing appeal?
we went over it, yes.
Thank you. And Your Honor, for a factual basis, on April 2nd of 2022, an officer from the Atlanta Police Department responded to 6968 Mancha, and I apologize, I'm not from Atlanta, so I might have butchered that pronunciation, MANCHA Street, in reference to an aggravated assault. Upon arrival, the officer spoke with the victim, Ms. Sharika Price, who stated that her son, the defendant, Mr. Fernando Price, attacked her with a flathead screwdriver and a filing tool. This was the second incident at the location. Your Honor, the police first came out because there was a verbal altercation that happened about a chime card. It didn't seem that Mr. Price, the defendant, was able to understand that he needed his identification in order to be able to either take money or put money onto the card.
What's a chime card?
It's somewhat like PayPal, I believe. I think it's all digital. I don't think they have any actual physical locations from my understanding. But he was attempting to unlock that particular account, and a verbal altercation ensued. That's when the police came out the first time and just separated the two. The second time, Ms. Price did state that Mr. Price was banging on her front door and had a flathead screwdriver and metal filing tool out of a black bag that he was carrying and was threatening to stab her with it. Your Honor, I did speak with Ms. Price. She said that this was an isolated incident, that she firmly understood that it was just because Mr. Price has mental health issues and was not taking his medication on that particular day. She said she's never had any incidents with him before. As you might hear from Ms. Wood, the only issue is that she wasn't sure if he could come back to where she lives now because she does have a roommate, and her roommate may not be able to deal with Mr. Price's mental health issues. So she wasn't able to give me a firm answer on that today, but she absolutely said that she wanted contact with him and that she just wants him to stay in a program because she feels like when he has something to do and when he had been in previous programs that he was a lot better in terms of his mental health. So we would ask that you accept this negotiated resolution, Your Honor.
Okay, thank you. Ms. Mann, do you have, what do you have on Mr. Price?
Your Honor, there are 5 prior arrests, not including the one that is before you today. There is a probation violation on for 4/2/22. That was a first offender case. It was revoked on 5/2/22 for ag assault and explicit inflict pain to deprive essential services to disabled person, Your Honor. Nothing further.
Thank you. Ms. Tucson, is Mr. Price under probation supervision with that other case?
Yes, in that case with the it's the 18 SC, he has 2 months and 22 days left on the 18 SC 161138 for Fulton County.
Okay, so that is open and active, little bit left on it.
Correct.
Okay, all right, well, we should try to wrap that up today as well.
Yes, Judge.
All right, Ms. Wood.
Thank you, Judge. He is 24 years old. He attended high school at Booker T. Washington High School. He unfortunately did not graduate. He is a lifelong resident of the Atlanta area. He does, as Mr. Jordan mentioned, have family in the area. He has worked various landscaping companies in the past. Judge, he does have some severe struggles with mental health. Part of the reason that this case is kind of languished is because we were at one time trying to get him into behavioral health treatment court. We looked at some other programs that might be appropriate. What we have landed on now, so he's been accepted into Viewpoint for the mental health aspect. He is in the process. He's been visited and gone through the application process for Metro Community Ministries, which would be the housing component. As of today, Ms. Patterson does not have a firm answer from them. She also, in the meantime, had made a referral to PAD to see if they could maybe fill in the gap for the housing. As Mr. Jordan stated, we believe also that Mr. Price would do well with a structured program. And so that's why we were somewhat hesitant to move forward today just without having these key pieces in place. But we do appreciate the court working with us on this. Yes, mental health officer, we definitely think that is appropriate and needed here. And otherwise, we would just ask for all the credit that he's been in. He has been in 327 days, so since April 2nd of last year, Judge. And we ask that you accept the state's recommendation.
Okay. Mr. Price, do you have any questions about what we've been talking about?
No.
No?
No, sir.
Okay, all right. So, Ms. Wood, the Metro Community Ministries is an organization that will provide housing for Mr. Price. It's just, they don't have a bed right now, or it's not clear that he even is eligible. The way I heard you, it was, he's in, we're just waiting on a bed.
So I know that they saw him at the jail. They had a team come evaluate. And so I think they like pair up with different apartment complexes. That's my understanding. So they would be the ones that would be helping him get the housing situated, and then Viewpoint would be for the mental health services.
Sure.
And so that's, Ms. Patterson just indicated she would follow up with them, or to see if either Metro Communities Ministries or PAD would be quicker for housing.
So we just don't have the housing piece yet. That would be the last condition of probation, is that reside at housing provided by. Although I think we can do the sentence today. He just wouldn't be released until he is released to that.
And so then could we do something where I notify Ms. Nelson once I learn of which program it is?
Right. Okay. All right. So I find there's a factual basis for the plea. Mr. Price, when he wasn't taking the medication, he should had an episode and threatened his mother, which I'm sure is not what he intends to do normally. I also find that Mr. Price's plea is knowing and voluntary. No one's forcing him to enter this plea. And he has frequently consulted with Ms. Wood during this plea discussion. But I find that because of those consultations, his plea is knowing as well. I'm sentencing Mr. Price under the Probation Options Management Act. Mr. Price, we used to hand people the indictments to sign, but we don't hand pieces of paper around so much because of COVID. Is it okay if I sign your name on the indictment indicating that you are pleading guilty to the threats charge? Is that okay?
Yes.
Yes?
Yes,
Okay.
sir.
Ms. Wood
Yes, Judge.
and Mr. Jordan? All right. Behavioral health treatment court didn't work out. Did they explain why, or?
I think the nature of the charges gave them some pause.
Okay, I don't know that they're all that uncommon for BHTC, but you tried. Ms. Wood, do you waive any due process notice issues if I want to resolve the 18 SC probation case?
Yes, Judge.
Okay, all right. First with this case, count 1 has been dismissed. Count 2, I will sentence Mr. Price to 5 years to serve 10 months with the balance on probation. A special condition of probation is no violent contact with Shereka, Shereka Price. That's Mr. Price's mother. A second special condition is that you'll need to take all your medications that are prescribed to you, Mr. Price. So if a doctor says Depakote, you got to take Depakote, okay?
Yes, sir.
I will request that probation assign a mental health probation officer to work with Mr. Price. Mr. Price will need to participate in the Viewpoint mental health program. That's a special condition. Got to do that. And Mr. Price will be required to live at housing that is provided through either Metro Community Ministries or PAD. And he will be released only to that housing. So Mr. Price is going to actually stay put until we know that that housing is in place, and then I can sign a transportation order. Is it your understanding, Ms. Wood, that he would be transported not to Viewpoint, but to the housing, and then Viewpoint wraps around?
Correct.
Okay, good. Finally, in light of this new conviction, what I intend to do is revoke the balance of Mr. Price's probation in 18 SC 161138, but he will get credit for the time he served, which exceeds the balance of the probation. Mr. Jordan, anything else in Mr. Price's case?
No, Your Honor.
Okay. Ms. Wood?
No, Your Honor.
Mr. Price, I hope this works out for you. We're going to try to get you a safe place to live and get you that medication so that it'll be safe for you to spend time with your mom as well, okay?
Yeah.
All right, thank you.
Yes, sir.
Thank you, Josh. So that's my number, right?
All right, do we have anything else that we need, pretrial release, pretrial services or probation for? Because I think I'm in the Zoom. We can talk real briefly about Monday. Thank you, Zoom. Thanks, everyone. Thanks, Ms. Rivers.
Thank you, Your Honor. Have a great day.
Bye-bye.
Bye.
Hey, Ms. Tucson, before you go, we didn't get any information to you about Mr. Price. Are you going to get all that from Ms. Wood?
That's correct. I wrote it down here to get it from her and write up for the balance of the probation on the other case.
Okay, because we don't have an address yet for Mr. Price. It'll be whatever program Ms. Patterson is able, the housing assistant she's able to find.
And that's okay. I could also indicate that on the paperwork when I submit it to the field office.
Great. Okay.